Secretary of the Executive Office of Energy and Environmental Affairs and the Chair of the Energy Facility Siting Board. Before we get started, I will ask interpreters to provide instructions on using the interpretation services being provided today. Mr. Lee.
Thank you. The language announcements will now begin. We are providing interpretation services for this meeting in Spanish, Portuguese, Chinese, Vietnamese, and Haitian Creole, as well as American Sign Language. Whether you are here on Zoom, you will have access to interpretation services provided today. If you are here in the room, you can access interpretation using a receiver and a headphone set. They are available at the table at the side of the room. For those on Zoom, in just a moment, we will activate interpretation. You will see a globe icon button that says interpretation. Click the globe and make a selection for your preferred language, including English. Thank you. And now for Spanish, please.
Estamos proporcionando servicios de interpretación para esta reunión en español, portugués, chino, vietnamita y criollo haitiano, así como lenguaje de señas americano. Ya sea que se encuentre aquí en la sala o participando a través de Zoom, tendrá acceso a los servicios de interpretación disponibles el día de hoy. Si se encuentra en la sala, puede acceder a la interpretación utilizando un receptor y un juego de audífonos. Los dispositivos están disponibles en la mesa ubicada a un lado de la sala. Para que quienes están en Zoom, en unos momentos activaremos la interpretación. Verá un botón con el icono del globo que dice Interpretation. Haga clic en el globo y seleccione su idioma de preferencia, incluido inglés. Spanish is finished.
Thank you. For Portuguese, please.
Estamos oferecendo serviços de interpretação para esta reunião em espanhol, português, chinês, vietnamita e crioulo haitiano, bem como em língua de sinais americana. Esteja você aqui ou no Zoom, terá acesso aos serviços de interpretação oferecidos hoje. Se você estiver aqui na sala, você poderá acessar a interpretação utilizando o receptor e um fone de ouvido. Eles estão disponíveis na mesa ao lado da sala. Para aqueles que estão no Zoom, em instantes iremos ativar a interpretação. Você verá um botão com o ícone de um globo que diz interpretação. Clique no globo e selecione o idioma de sua preferência, incluindo o inglês. Obrigada, thank you.
And for Mandarin Chinese, please.
我们为本次会议提供西班牙语、葡萄牙语、中文、越南语、海地克里奥尔语以及美国手语的口译服务。无论您是在现场参会还是通过 Zoom 线上参会，今天都可以使用口译服务。现场参会的与会者可以通过接收器和耳机使用口译服务，设备可在会场一侧的桌子上领取。通过 Zoom 参会的与会者，稍后我们将开启口译功能，届时您会看到一个写有 Interpretation 的地球图标按钮。点击该图标，选择您偏好的语言，包括英语在内即可。谢谢 ，Thank you.
And for Vietnamese, please.
Chúng tôi đang cung cấp dịch vụ phiên dịch cho cuộc họp này bằng tiếng Tây Ban Nha, tiếng Bồ Đào Nha, tiếng Trung Quốc, tiếng Việt và Creole Haiti, cùng với ngôn ngữ ký hiệu Mỹ American Sign Language ASL. Dù quý vị có mặt tại đây hay tham gia qua Zoom, quý vị đều có thể tiếp cận dịch vụ phiên dịch được cung cấp ngày hôm nay. Nếu quý vị đang có mặt tại phòng, quý vị có thể sử dụng bộ thu sóng và tai nghe để phiên dịch. Chúng tôi có sẵn tại bàn ngay bên hông phòng. Đối với những người tham gia qua Zoom, trong giây lát nữa chúng tôi sẽ kích hoạt tính năng phiên dịch. Quý vị sẽ thấy nút biểu tượng quả địa cầu, globe icon có chữ Interpretation, tức là phiên dịch. Hãy nhấp vào quả địa cầu đó và chọn ngôn ngữ quý vị muốn nghe, bao gồm cả tiếng Anh. Xin cảm ơn.
Haitian Creole, please.
Bonsoir tout le monde. Après-midi, nous gagnons un service interprétation qui est disponible pour tout le monde dans la langue sayo. Nous gagnons langue espagnole, portugais, chinois, vietnamien, créole haïtien, ensemble avec langue ancienne américaine, ASL. Qui tout ici là sous Zoom ou bien qui tout dans la salle en personne, ou besoin de service interprétation nous offrir aujourd'hui. Si que ou ici là physiquement dans la salle là, ou capable besoin accès ensemble avec service interprétation avec un casque récepteur et puis un écouteur. Appareil ça est disponible sur tout sous table l'autre bord. Et pour moun qui sous Zoom yo, nan yon ti moment, nous pourrons activer service interprétation sous Zoom nan pour nous. Les nous activer li, wap remarquer wap wè yon bouton icône globe qui dit interprétation. Wap sélectionner interprétation. Après ça, ou sélectionner langue ou préférée tade à réunion aujourd'hui. Ça qui inclut langue anglais tout. Merci à pile pour compréhension nous tout. Interpreter completed the instructions. Go ahead.
Language announcement completed. Thank you.
Okay, we'll turn the interpretation feature on at this point. One other instruction to provide is that Zoom also provides translated closed captions. Press the Show Captions button at the bottom of your screen, then press the up arrow and select My Caption Language and the specific language you want. Secretary Tepper, back to you.
Thank you very much. Again, everyone, welcome. This is a hybrid meeting of the Energy Facility Siting Board taking place at the offices of the Department of Public Utilities, 1 South Station, Boston, and on Zoom. This hybrid meeting format is intended to allow everyone to see and hear all speakers, whether here or on Zoom. With me today are the other members of the Siting Board. Jerry McDermott, Chair of the Department of Public Utilities. Stacy Rubin, Commissioner of the Department of Public Utilities. Elizabeth Mahoney, who is online today, Commissioner of the Department of Energy Resources. Bonnie Heipel, Commissioner of the Department of Environmental Protection. Is Doug here? Hi, Doug. Doug Goutreau, Director of Permit Regulatory Office and designee of Eric Paley. And Joe Bonfilio, who is our public member, who's also online today. And additionally, Andy Green, Director of the Siting Board, is here with the board and will be serving as our Zoom meeting host. The meeting today concerns the Siting Board's role in implementing the 2024 Climate Act signed into law by Governor Healy in November 2024. The 2024 Climate Act makes many changes in the way that clean energy facilities will be sited and permitted in Massachusetts. The Siting Board is required to promulgate regulations and guidance to implement these reforms and will apply to projects filed with the Siting Board starting in July 1, 2026. The board will meet today from 1 to 5 p.m. and will continue tomorrow if necessary from 9 to 1. The purpose of today's meeting is for the Siting Board to discuss the draft final regulations implementing the siting and permitting reforms from the 2024 Climate Act. These draft final regulations include chapters 980 CMR 1, 2, 13, 14, 16, and 17, and proposals to repeal 980 CMR 4, 5, 7, 8, and 11. The Siting Board will not be voting on the regulations at this meeting. We will have an additional meeting in February to vote on the final regulations. Today, we will listen to the staff providing us details with respect to what is new in the regulations from the last time we looked at them, and have a brief opportunity for people to comment. There'll also be another opportunity for people to provide written comment until the close of business this Friday, January 9th. Today's meeting follows earlier action by the board that opened a rulemaking in EFSB 25-10 for EFSB regulations required of the Siting Board in the 2024 Climate Act. We have held a series of formal public comment hearings on the earlier set of proposed regulations and received comments. The cumulative impact analysis site suitability regulations are not included in this package of the draft final regulation and are on a slightly delayed schedule. We are intending to finish the regulatory process for the site suitability and CIA regulation by May 2026. The other regulations will be promulgated by March 1st, 2026. The Siting Board has received numerous oral and written comments to date, which have been posted in the file room, EFSB DPU file room. As a result of the input from Siting Board members and comments from agencies and the public, Siting Board staff further refined the final regulations, draft final regulations that we are considering today. For today's meeting, staff will provide a briefing on draft final regulations and update the board on comments made and changes in response to those comments. The board will then ask questions, provide feedback, and we'll also have some time today to listen to public comment and questions regarding the proposed draft final regulations. As a reminder, we are on a very tight schedule to develop these regulations in time to meet the statutory deadline. To set expectations for today's meeting, I note that all the materials presented by staff today will be posted online later. Early next week, the final draft regulations will be submitted to formal interagency review. A board vote to promulgate the final regulation and issue a final decision will take place in February 2026. The regulation will then be submitted to the Secretary of State and published in the Massachusetts Register in time to meet the March 1, 2026 statutory deadline. The Siting Board provided notice of today's meeting to the Commission on the Energy Infrastructure Siting and Permitting, a broad group of stakeholders and member organizations, the Siting Practitioners Advisory Group, and an interagency task force for siting and permitting. The notice was also posted on the Siting Board's website and provided under the Massachusetts Open Meeting Law. So the way it's going to go today is first we're going to hear a presentation of the regulations from staff. Then the board will ask questions of the staff, and then we'll have an opportunity for public comment. And we'll probably take breaks around 2:30 and 3:45. All right, we're good. So, as I mentioned, the sole item on our agenda today is to consider the draft final regulations. So, Ms. Evans, would you like to start us out?
Great. Thank you, Chair Chepper. My name is Joan Foster Evans, and I'm the General Counsel of the Energy Facility Siting Board. With me here today are three of our presiding officers from the Siting Division, Donna Sharkey, Connor Tarr, and Daniel Kelleher, who together with myself will present the changes that we recommend from the comments we received on the Siting Board regulations. Just very quickly, the goal of the meeting is to review the comments we received and for staff to explain its recommendations regarding those comments, what we recommend changing, what we recommend keeping the same, and our reasons, and to answer any questions about that, and give you an update on what else is happening regarding the siting and permitting regulations. Next slide, please. So this slide is a general slide about the 2024 Act. I think we've been through this multiple times, but helpful to have it again on the website when these slides are posted. So I'll keep moving, please. And we also note that these are the different chapters that we were proposing to refine and revise. Some new chapters and a set of chapters that we propose to repeal. I will note on the repeals that the chapter 980 CMR 9 is no longer listed on that list. We did hear from the Office of Coastal Zone Management that they actually use those regulations and asked us not to delete them. So in the final regulations, we will recommend not deleting 9.0. I will note that the 980 CMR 15, which are the CIA and the site suitability regulations, as stated before, are on a slightly different schedule. And I'll note that also the two regulations to be promulgated by the DPU, the Department of Public Utilities, are also on a slightly different schedule and a different process because they don't involve a board meeting. Finally, the Department of Energy Resources is out ahead of all of us. Their regulations, I believe, are with the legislature, and they, I believe, are planning on promulgating by March 1st also. Thank you. Next slide. So a very general note, this is the regulation development. We went through a rather extensive informal process in the spring and summer, and then we went through our formal rulemaking process this fall. And that included issuing the proposed regulations, holding a series of public comment hearings. We held 4 public comment hearings, all of them hybrid, all of them across the state, in different places in the state. And we received a number of written comments. We received, what way we set it up was some initial comments and then reply comments at the end of the public comment hearing process. And we heard from hundreds of different entities with suggestions on how to improve the regulations. And that's what we're going to present today. Next slide, please. So just to put this particular meeting in context, I wanted to note what happens next. We are providing a very short window, and we understand it's very short window for some additional written comments, although we do note that there's no additional written comments that are required. We're actually providing just a little bit extra from what is required under the rulemaking rules. We plan on sending the regulations up to formal interagency review next week. We have a deadline to issue those final regulations to the Secretary of State by February 13th so that they can be published on February 27th, making the March 1st deadline with 3 days to spare. And then the statutory deadline, of course, is March 1st. I would indicate two other points. Even though we'll have the regulations promulgated by March 1st, we have a window between March 1st and July 1st before the program goes into effect. And we think, staff thinks that there's a lot to do during those 4 months to work on very detailed practices and procedures in order to be ready for the July 1st deadline. So we intend to continue stakeholder engagement during that time, meetings, possibly webinar. We probably will need to come up with some kind of educational system to roll the regulations out so folks know what are in the final regulations. So I did want to note that that will be happening over the spring. I will note the other items not on this list, but are going on simultaneously, 3 other items. So the board staff still need to issue baseline standards and common condition documents to the public for comment and to the board. Those have lagged behind some of these other things. Those are coming, those are developed, those are in process of being reviewed right now and will be issued for public comment. Obviously, we have the completion of the cumulative impact assessment regulations. Those will happen this spring to be finalized by the beginning of May. And we also have in process the development of a new web portal in order for folks to file the materials necessary during the consolidated permit process. So that is happening this spring also. Okay, next slide, please. So as I stated, we received hundreds of comments and a couple of broad things that we heard. We heard from commenters requests to add more specificity and certainty in the siting and permitting process, but we also heard we should be looking out for flexibility in the siting and permitting process. We also heard that from some commenters looking for a more robust participation and more defined roles for the public in our processes. We heard a lot of arguments for and against, or not for and against, but different ways of approaching how to have efficient proceedings, more efficient, go faster, go slower, provide more opportunity, provide more time, provide less time. So we were trying to balance all these types of comments in our recommended changes to the regulations. Also, I will note also that we had quite a few comments that really talked about how we balance what is specific in the regulations versus what is more flexible in the guidance. One note I want to make on the guidance documents that board staff has put together is that we've included a process such that when guidance documents are changed, we suggest very strongly that the board review those changes to the guidance documents and vote on those after notice and an opportunity to be heard. So while those are not regulations, we think that this provides some procedural specificity and some procedural safeguards for changing guidance that's referred to in the board regulations. So And then lastly, just say, we've spent an awful lot of time coordinating and collaborating with other agencies, especially the EEA agencies, DOER, Mass DEP, Fish and Game, and many other agencies to work through exactly how this is going to operate come July 1st. Thank you. So I'm going to talk just briefly about the adjudicatory proceedings. There's several adjudicatory type regulations. I'm not going to go through the details of what the current, the Act requires in the adjudicatory proceedings. That's this slide and the next slide. But I'd like to talk about the comments. So mostly the comments that we heard on adjudicatory proceedings that are 1.0 regulations was asking us to look at more definitive timelines for certain actions that must be taken. And then there's also, we had to balance that against the flexibility for a presiding officer to set a proceeding in order to respond to particulars of a particular project or particular proceeding. So we took a look at that and we did add some more specificity on timing. We heard a number of comments regarding how far notice should go, who should be getting notice, and in general, who should be receiving various types of documents. And then we heard a number of commenters about intervention. So I was going to go through these briefly. And excuse me, sorry. So we had some commenters who talked about how we reflect the cumulative impacts or cumulative burdens of projects. Clearly, we have the cumulative impact analysis regulations that we spent a lot of time on, the board voted on last meeting, and go into very specific ways to look at cumulative impact analysis. We do note that there is a general provision in section 69H which requires the board to look at cumulative impacts and give them due consideration, and that does appear in the regulations. We had several comments about the project segmentation provision that was added into 1.0. Several folks, including the offshore wind and the utilities, indicated there are certain requirements at times that may make a developer phase the installation of a particular, or phase the permitting of a particular type of project. For instance, we heard about South Shore Wind. There was a federal requirement that caused South Shore Wind to split that project into two 1,200 megawatt cables as opposed to just one 2,400 megawatt cable. So we wanted to reflect the flexibility for developers to phase a project when necessary. And we added that language in certain situations. We added it into 1.0 into the segmentation section in order to allow flexibility in certain circumstances from that provision. Again, we heard extension of time provisions. We did not change the regulations on some of these requirements in that we think that we have provided and included some language in the regulations that anticipate if someone is gaming the system timing wise, that there are actions to for the presiding officer to respond to that and to ensure that that doesn't derail the schedule of the proceeding. We heard from Mass DOT about energy storage, mobile energy storage equipment, as in cars and buses. And we didn't change the regulation on that, but that's something we need to think about a little bit more on jurisdiction over those types of facilities. We've actually also heard about jurisdiction when a developer installs multiple, say, diesel units as diesel generating units, whether that would actually trigger some kind of jurisdiction. We didn't think that these types of questions belonged in the regulations. We were asked to put in more specificity on timing on the project change provision. Again, this provision is new to the regulations, although the regulations do reflect a longstanding practice of the board for project changes. And it was hard to pick exactly what timing to put in there because project changes are super fact specific. Some of them are very big, some of them are very small. Developers are required to notice us about the project changes, but we did put in a timeline for at least the initial assessment of whether a project change requires some additional process because it's big enough to require additional process, and we added that in. We did also adjust the notice regulations to reflect a difference between large and small storage and generation facilities. So we made the notice requirement smaller for the small facilities and larger for the large facilities. So that change is in 1.0. And that's what I have for 1.0. I'll keep going on 2.0 because it's somewhat related. 2.0 is the board business, how the board operates. And we did not get very many comments regarding the board business regulations under 2.0. We did hear some concerns about whether or not the board, you can go to the next slide, please, whether or not the board should be reviewing cost or financial information for merchant projects. And so we did not change the regulations on that. We left the regulations the way the statute lays out the cost requirements. But we do note that as board practice, we do not delve deep into cost issues for merchant projects, whether it's a merchant generating facility or a merchant possibility of a transmission and distribution facility that's provided by merchant, substations that are provided by offshore wind companies, that type of thing. So we did not change the regulations on that. And then we had a couple of comments regarding the makeup of the board, who should be on the board. And we do note that we did not change the regulations because, quite frankly, the board makeup is specified in the Act. And we did not think that we could change that makeup without changing the Act. So those are my general comments on the two procedural regulations. I'd like to now either take questions or send this over to Donna Sharkey, who's going to tell you about the de novo adjudication provision.
I'm thinking maybe we should just do some questions if we have them now so that before people forget what their questions were. So if anybody has any questions on those first two regulations.
It's not so much, well, I guess it is really a question. Thank you you had mentioned before consulting with many different entities throughout the state, including DEP. So thank you for all of the time spent doing that. One of the issues we had been discussing was the specific Clean Water Act 401 dredging permit that has federally required timelines that are different than what's set up in these regulations, and just trying to find the right place in the regulations to make clear that that will continue on its normal course because it can't be swept into new timelines without conflicting with federal law. The suggestion that we had was to put that in 1.01 sub 4, the definition section, just to get that out there up front that when we define permit, we sweep in municipal, regional, state permits, authorizations, et cetera, and accepting this one specific permit that has just this different timeline established by federal law. So wanted to just flag that as something that could live in 1.01 sub 4 as a definition, but open to other ideas about the right place to make that clear to folks.
So we have discussed with DEP staff the incredibly short time frame for the 401 water quality certificate. The Act provides the ability for the board to determine whether or not federally delegated permits should be included in the consolidated permit. There may be others besides that one that also the board may want to consider excluding for various reasons, for timing, or just the jurisdiction doesn't line up. And we can include the 401 certificate there, or we could have the board make a more holistic determination about what types of federally delegated permits, which federally delegated permits it should exclude from the consolidated permit. We could do it either way, do it this one particular one, or do it a little more holistically.
We had talked about the same thing internally, whether it makes sense to have sort of more general language, permits that have a federally established timeline that conflicts with. I was in favor of doing it in this more specific manner, just for clarity for everyone, right? If you're an applicant coming in, you have clarity on which permits are outside of this process from the get-go. But if we think there are others with other agencies or others that people just have questions about, doing it in a more general way may give us the ability to continue that conversation. That's the one that DEP has in mind.
Thank you. I'm not sure if the Division of Fish and Game might have some that might fall in this. I will note, and we can add this in, I will note that we created a new category of permits called ministerial permits, because we have the opposite situation where we have permits that actually a developer may not have the information till much later than the consolidated permit, maybe a road opening permit, that type of thing. So we did provide a provision to allow the developer to include those permits after the consolidated permit process is done, and let the director issue those very ministerial, smaller permits that happen later on. But yes, we can go ahead and put the 401 in this, excluded here, and maybe expand the language, which I can't remember where it is right now, the language about the board's ability to exclude other federally delegated permits. Thank you.
Is that in the regulations already, that part that you just said?
It is in the
You do not
Act.
need to find where, it's fine. It's just
I think it is. I know that it's in the Act. I think it is, but I can't, without flipping through, I can't figure out where it is.
Yeah,
Let me see whether it might fit there better.
I would just say that we don't want to be in a situation where we talk about one permit and then we find out later that there's 3 other ones, right? So I would either specifically add this permit to this provision, or I would make it clear that in another provision that the federally delegated permits are excluded, or can be excluded, or however you want to deal with it. I just if we want to figure out which permits fit and name them all, that's fine too.
Might have.
I think there might be a
difficulty doing that
CZM one.
between-
I mean, I think there might be several.
I think that there are others,
Yeah.
yes. But I'm not sure that we could name them all between now and Monday. But let us take a look
Okay.
further at that, and we could talk with DEP staff about that.
Great. Thank you.
Can I just quickly add, I think in 13.05 subsection 1C, we talk about federal permits. So that might be a place to add this, maybe in addition to the definition of permit in 1.0. But just noting it is in here in 13.
Thank you, because it would only apply to a consolidated permit. So that makes a lot of sense.
Yes.
Mhm.
Would anyone have any further questions
I
on
had
one and
one
two?
question on the jurisdiction of the storage systems. So what is if we're not going to decide now what is in and what is not in with respect to storage facilities, what's the plan for doing that?
So we have not looked at mobile units before. I think the assumption would be they would not be jurisdictional. But we did not have a plan to review and make that determination. We don't have a definite plan at this point in time to review that and make any kind of determination. It seems like that might require a little more process before we were to make such a decision. but we could do the process now and figure that out.
No, I don't think at this point you want to do that. I guess, I mean, we don't think that the statute is clear on it.
The statute does not indicate stationary versus non-stationary.
It says storage.
Correct.
But would siting only apply to a stationary facility? You're not citing a mobile source that can move around.
That seems to make sense. My understanding is from the MassDOT comments that they possibly have a place where they put their buses to interconnect with the grid, is the kind of the idea. And then all of a sudden, all those buses would be in one place and they have storage facilities, they have storage capabilities. I think this question requires a lot more.
It's a little more complicated. Okay.
It's more complicated, and I think we did not change the regulations for it. It's a question that possibly want to explore later, but I think we need more information before we can make a really an informed recommendation to the board on this.
Okay.
Any other questions? Okay.
Thank you. John is going to present from over there.
David, do you need to adjust for that? Yeah.
You are.
Okay, thank you. So, I'm, yep, up. It's on, but it's not. Okay, I'll hold it. Thanks. So we're dealing with the question of 980 CMR 14, which is de novo adjudications. It is a very limited slice of jurisdiction for the siting board related to consolidated local permits for small clean energy infrastructure facilities. They're generally regulated by the Division of Energy Resources regulations at 225 CMR 29. However, there are two instances in which proceedings relating to those underlying consolidated local permits could come before the board. One is where certain entities object to the decision that was made on the consolidated permit at the local level, and effectively we serve as a review and appeal process under the direction of the siting board director, who would review the record and make a determination, which then could be appealed directly to the Supreme Judicial Court. That process is scheduled for a 6-month timeline. There's a secondary process potentially, which is essentially a fail-safe when the local municipality feels that it lacks resources to review the consolidated local permit as it's been filed and requests the siting board to basically undertake the review for them. That's a process that would take 12 months, again, with the decision made by the siting board director. There were concerns raised by commenters with regard to the role of regional planning agencies and how they would interact with local authorities. I would note that regional planning agencies are included in the definition of local governments. So our expectation is that there would be coordination between the regional planning authorities and the local government with regard to the consolidated permit. There were questions about whether there was sufficient timing for the local government to respond to proceedings being conducted under these regulations. And we have not made changes, but we have tried to clarify the amount of the timing that would be afforded to the local government to respond to cases proceeding under this regulation. The always popular question relating to zoning has been raised. And if a developer does not file an application for a consolidated local permit, they would not have the ability to come to us and have de novo review. However, they could proceed with whatever's happening at the local level for a consolidated permit and still come to the siting board for zoning exemptions if needed for the project, because 69W of the Act does not include provisions that would prevent them from coming to us. In light of those questions, I think if you can see from slide 15 and then moving on from slide 16, there's generally no changes to the regulations. But if anyone has any questions, please let me know.
Thank you very much, Ms. Sharkey. Just a quick question. I know we got comments on intervention and whether key stakeholders should automatically be granted party status. And I support not making any changes, but I just wonder if you can articulate how a presiding officer would make a decision on a petition to intervene and determine whether an entity or a person is substantially and specifically affected.
I guess it basically would be the same standard that we use now in our proceedings, where we assess the rights and the interests of the individual with regard to the action that's been taken. And if in fact they had rights that could be affected, then they would generally be granted intervention in the proceeding. They need not have participated at the local level in order to participate in the de novo proceeding.
Great. Thank you so much. Very helpful.
Commissioner Mahoney is raising her hand.
Thank you. And thanks to the team. Sorry, I'm not there. I'm just curious about 1404, the adjudicatory procedure, and then paragraph 3, DOER opinion. The director may request a DOER opinion from DOER. I guess can you walk through that for us? Because it's DOER opinion is defined as an opinion assessing a local government's compliance with DOER's regulations in its review of a consolidated local permit application. It's not our understanding, reading our regs, that we're reviewing a consolidated local permit application. So just wanting to see what is trying to be achieved here and make sure that we're getting the language right.
Well, I guess my understanding of the DOER regulations and guidance is that it covers things, for example, like site suitability criteria, and it would cover things like outreach, because these proceedings are not covered by 980 CMR 16, which is our otherwise pre-filing outreach regulations that apply basically across the board to all the other facilities. So I think it's more of a request to make sure that the standards that are contained in the regulations and that potentially were contained in the model bylaw, which may or may not have been adopted by that municipality, were generally followed as part of the permit filing and whatever review was done.
Thank you. I'm trying not to do it on the fly. I might come back before we close the hearing. I just think there might need to be some clarity here to limit it to, as you have noted, where DOER is actually working with the municipality on those limited circumstances. Because I don't want parties to assume that DOER is doing some sort of review of the process, trying to walk a fine line between what is EFSB's authority and the director's authority in this role versus what steps DOER has taken throughout the process leading up to the de novo review. So it just might require a tweak to be very clear that we are not creating more authority for DOER, and also trying to get the director the information necessary on those pieces that DOER is going to work on.
I think part of the issue for us is that we want to make sure that we're consistent with the DOER regulations and practices, and that potentially, as this is going to be kind of a new effort for both us and for DOER, we want to ensure that there's consultation with DOER with regard to the process that was conducted at the local level. Does that help?
It does, but then I think we need a DOER opinion, or is it a consultation?
I don't think that the expectation is that there would need to be an official opinion, particularly as part of the process, but that there would be a consultation. And if there's a consultation, I would assume that it may result in some written document from DOER that would be helpful to us in terms of the review of the underlying record.
That's helpful. I know we're going to go to, public and others, so I might just work on the side on effectuating that language into a kind of how you laid it out into the regs. And maybe I'm going back to my old life as a lawyer and thinking DOER opinion has more weight than what you're implicating here. So I just want to make sure the words are right. So again, or as you noted, staying consistent between the two agencies' regulations, but also giving the director the information that's necessary to make a decision here on a short timeline.
And we would certainly hope to cooperate with DOER with whatever particular processes and degree of formality they feel would be helpful in terms of moving the process along.
I also know that if, maybe it's just the one word change, Commissioner, you can look at it, but also there's an opportunity in the final decision to clarify as well, if that's helpful. Sure.
I just have one quick question to understand the level of discretion that the director has in whether to grant a petition for de novo review. I noticed that it is a petition in 14.02, but how much leeway does the director have to accept or deny a petition for de novo review?
I believe that the director would have complete discretion to determine whether to review a petition, look at and determine based on the initial filings whether it was appropriate to proceed.
Okay, maybe I may want to take that offline and understand a little bit better, but it would be, I think, be good to have the rules of the road clear for all parties about what the level of discretion is to initiate a de novo review? Is it just that a party that has substantial interest files, or is there some degree of decision making that happens before launching into a full de novo review?
Well, I believe if someone files a petition and it's under kind of the 6-month review because they have an issue with the underlying decision, that we would be obligated to make a determination on how to proceed with that petition.
Okay.
If I could add to that, I think it's a great idea to include some more clarity in the decision, the tentative decision, when that comes to you next month, about when, what the level of the director's discretion. I think the discretion is in two parts. First of all, there has to be somebody substantially and specifically affected in order for like the first track of de novo review, the kind of review part, to go forward, because the proceeding below in the local level is not an adjudicatory proceeding, there's no determination of who can meet intervention standards. So the director would have to make that determination, right?
A threshold question about
It's a threshold question. That's exactly right. I think the other level of discretion is simply the request coming up. Is it within the scope of the local consolidated permit, or is it for some other reason? And we see, complaints or that type of things are outside of the scope. It would have to be a decision of a local government comes up. It's got to be by somebody who has an interest in that local government's decision, and also just has to simply follow procedurally, have the right things attached to it. It's got to be in 30 days. It's got to, those types of things. So those are all determinations that the director would also make. But we can clarify that even more in the tentative decision.
I think that would be helpful.
Undersecretary Judge, did you want to add something?
I was just going to make a point of clarification on the discussion about the DOER opinion earlier. I think, as I understood this, there's going to be parties that are coming into a proceeding, and there's going to be a potentially contested view of facts, right? And so you may have a developer presenting one set of facts, a municipality submitting another set of facts, and making assertions about DOER's regulations. And I think the intent there is in part to allow DOER or have DOER come in and say, well, this is the accurate way to interpret that rule. And so I think that was more my understanding of how that opinion process worked. I agree, maybe there's some fine tuning of that language and the clarification of like how you're describing that in the regulation that might be necessary. But just I wanted to offer that point of clarification from my perspective, at least, on how I thought that would work. I don't know if that helps, Commissioner Manny.
I understand the goal. I just I'm playing with the language.
No, I agree. So that's all.
Any further questions on de novo?
Chair, I have
Yes.
one more.
Sure,
Thank
of course.
you. In 1405, the decision, standard for decision 1A, the director shall review the final decision for consistency with DOER regs and MGLs. What happens? I just want to make sure we're all clear on coming back to Ms. Shockey's point earlier about making sure that we're all aligned. And so far, we've obviously worked quite well together and are very grateful for the collaboration. I'm just thinking about in the future, what happens if there's a tweak in either one of our regulations that we somehow miss, and it creates some inconsistency between the regulations. When it comes to the director's decision, whose regulations win out in a fight, and do we need to make that clear here? And not a fight, I mean, of course, an inconsistency, unintended.
I'll defer to Joan.
She heard the word fight, and I got up. So that's a great question. We included in the proposed regulations a two-part standard. First part being consistency with DOER's regs, which is what the Act says, right? And also consistency with 69H. And the reason that's in there is a general consistency with the board's statutory mandate, right? So the board acts as almost as an overlay within its statutory mandate, and that was important to recognize that there. It's hard to say who's going to win a fight. In theory, I think that bottom line is any decision the director makes needs to be consistent with the act, and we would need to figure out how to reflect that consistency with the act. And it would depend, I think, on the nature of where the two regs possibly might not line up. But the 69H was to recognize the board's overall statutory mandate, and that's why that is there.
Okay, thanks.
All right, let's move on.
So next is the question of pre-filing consultation and engagement requirements, 980 CMR 60, which applies to all facilities essentially, with the exception of those related to the de novo adjudications. There has been extensive commentary throughout this process on pre-filing outreach. In particular, the definition of community. We have made changes in the most recent set of regulations to define community as within the geographic scope of potential environmental and other impacts of a facility to the surrounding area. And as changes may occur for specific facilities, as they're set forth in the cumulative impact assessment regulations. That's probably one of the most significant changes, but that was the goal basically in making that change, was to ensure that the definition captured the potential impacts to surrounding residents based on the type of facility. Second, there were a lot of questions about the distribution of information and materials, both to members of the community and how that would be undertaken, as well as to providing information to agencies who would be involved as part of the pre-filing outreach for potential facilities. The third probably area in which we've attempted to reach some clarification was with regard to both the waiver process and the DPP opinion process. There were a lot of concerns I think people have expressed with regard to waivers and the discretion of the DPP director to issue waivers. One of the things that we have addressed in terms of the regulations has been to ensure that waiver requests are posted on the project website as well as distributed throughout the community outreach with people who have been participating in dialogue with the developers, such as through outreach meetings and other channels, including meeting with the municipalities. People are concerned, I believe, that waivers might be regularly granted somewhat willy-nilly. And I think that it should be clear to everyone that the waiver requests will be decided by the DPP director, who has the obligation for enforcing the outreach requirements and who has that obligation across the board for all facilities that come before the board. So it's appropriate that based on her obligations and her understanding of how the outreach process should work, that she could determine in individual instances whether or not a waiver is going to be required. There's also concerns with regard to waivers, I believe, because many projects have already initiated outreach who have not yet filed with the siting board and who will expect to be filing under the new regulations when they become effective in July of 2026. And they have concerns that steps they have taken as part of their outreach, which were not taken with an awareness of what regulations would be applicable under effective July 1, 2026, might not be deemed acceptable. I think that's part of the reason why the DPP director has the ability to allow waivers, which may happen if the activities that a developer has undertaken are consistent with the spirit and of transparency, full communication, dialogue with the community, dialogue with the agencies. And to the extent that that happens, she will determine whether or not issuing a waiver is necessary or appropriate. Similarly, there were questions raised with regard to the decision of the DPP director, which is one of the last things to be filed as part of a when someone is filing an application with the siting board. There were concerns that agencies wanted time to review the completeness of a potential project's applications, particularly as it may relate to their permit oversight for that facility. And they wanted time to be able to provide comments on that once a notice is filed by an applicant that they're intending to file an application. Applicants understandably wanted the ability to respond to that comments that may be filed or comments that may be filed by other members of the community with regard to what else might need to take place with regard to the application. Therefore, we've changed the timing to require the notice of intent to file an application to come in earlier, then provide additional time for agencies and members of the community to respond to those, to the information presented, and then to allow the director to address those and review those in developing her opinion on the sufficiency of the outreach activities. So there's, as we go through the slides, if we look at 16, you can see there's relatively little change in terms of the language of the regulations, but there is clarifications provided as a response to fine-tune the information that might be provided with regard to meetings, with regard to comment periods, and other requirements as part of the outreach obligations. One thing that is also we wanted to mention is that MIPA and the Office of Environmental Justice and Equity maintain a list of areas in the state and types of facilities. And people can sign up if they'd like to be notified if an application is filed, if a project is filed in a particular area. And that's an additional way for them at a very early point in the process to receive notice of a particular facility being proposed. The siting board and potentially other EEA agencies are contemplating setting a process up for people to sign up for those types of notifications, perhaps as a side part of the portal that's going to be developed for siting board and other applications. But until that is developed specifically for the agencies, we would recommend that people contact MIPA, contact OEJE, and sign up for notifications if in fact they would like to receive some type of email notification if it's a project is proposed for a particular area or if it's a particular type of project. Does anybody have any questions?
Yes. And then going back to the beginning, your first comment about the definition of community, which I think you were wise to highlight since so much of this section keys off of that definition. I'm just trying to understand what this change actually means instead of defining, facility types and relative distances here. We're cross-referencing to the CIA table of facility types and distances, which look to me, just looking on the fly here, to be fairly consistent for most facility types. Is that right?
I think that there are specific differences. For example, not that we've seen any particularly lately, but if, for example, there are generating facilities which require air permits, the notice provisions is I believe 5 miles for those types of facilities because of the greater potential for air impacts based on dispersion. It's much more limited, for example, for say transmission lines being installed in an existing right-of-way.
Right. Yeah, it does look like the major differentials are for the fossil facilities. I'm trying to think through a cross-reference to a reg that doesn't yet exist. Do we think that because the CIA regs will closely follow on the heels of promulgation of these regs and everything will catch up by the July 1st implementation date, that we can be comfortable doing that?
I believe that the CIA regs, while they are behind the rest of the regulations the board is promulgating, are still obligated to be done on a very expedited basis. And our expectation is that they will be in place by July 1st.
I guess I'm just trying to think through both timing wise and substance wise. Is there a reason not to just import that table and put it here and have it all in one place instead of sending people to things that are elsewhere and or not yet final?
Well, actually, there was a draft that had the language from the CIA regulations. And then the concern was if there were changes in the draft language within the CIA regulations, that might not be captured. And we wanted to be consistent. We did not want to, be inconsistent with what would be kind of the later and most recent determination by the board for here's the geographic scope of potential impacts.
Given
Okay.
the choices, that seems to be the better way to go between the two.
Yes, where we are at the point in the process, I think I would agree.
But I appreciate your concern.
Thank you.
I have two points on this. Thanks for the excellent work. I know this particular section 16 has been complicated. On the waiver piece, it was helpful to hear your presentation that you have recommended this language because you want some one, it's in the statute and we need to reference the statute, and two, for the transition period that the DPP director needs some flexibility. I'm just wondering if you can give an example of a scenario where it may, perhaps the DPP director would be willing to grant a waiver after the transition period is complete. And as you're thinking, my sense is that we are wanting to limit the number of waivers we are making from the pre-filing requirements, but I just want to hear staff thinking on that.
It's true that we were primarily concerned that there needs to be much more flexibility potentially as we're moving through the transition period. The other, I guess, concern is in the future, if there are, for example, new types of facilities that are proposed that are not, included in the current statute as jurisdictional facilities for the board, that there may be additional, for example, requirements that the DPP director may see as being necessary for, say, a new technology. I can't think of anything in particular, but for example, I know there's been discussion about, say, new small nuclear generation facilities. It would seem that the requirements would be consistent for those types of facilities, but there may be some additional feature associated with the technology where we may want to require different types of notice to different community-based organizations. Sorry.
I'm just going to add to that. Thank you, Donna. Another thought. First of all, again, something good to put in the tentative decision to say that this was the intent of this provision. It intended to focus on the transition, but also is intending to be narrow. I could think of a situation, again, hypothetical, where a developer tried to engage with a local community and the local community was absolutely unwilling to engage in any way, shape, or form. There might be a unusual situation like that where this gives the DPP director an opportunity to kind of engage in that situation and perhaps give a waiver or a partial waiver to a developer that's honestly trying to engage with a particular community and the community is simply refusing to engage. I mean, that's an outlier situation, but again, I think for us to indicate in the tentative decision our intent on what this provision does and how we would use it, I think would be really helpful to set that expectation going forward.
Very helpful answers. I do think we'll want some maybe more detailed language in the TD on this particular point. So I look forward to that. And then my second point here is in 16.10 4B. This is where I know we got comments from the utilities and Ocean Winds about wanting to, basically respond. I just want to make sure that there is language in here that the applicant receives a copy of comments from local government. It's not clear to me in 4B that language is there. We've added language to say the applicant may respond to comments, but if the applicant isn't receiving them, it just says the comments are filed with DPP. So I don't know if I'm missing language or maybe we could just be clear. I want to make sure the applicant has comments about its project so that it can respond.
Certainly, the intent was that the applicant would receive copies of all comments from any source, either in the community or from agencies, and then have the ability to respond to those.
I'm just asking staff to go back and make sure that that's clear in the regs. Thank you.
Any other questions? Nobody online? Okay, then let's move on. Good idea. All right, we will take a 10-minute break. Being back here at 2:30. Ms. Evans, how would you like to proceed?
Yes, thank you. We're going to proceed now with comments on 13 and 17, and they're going to be presented by Connor Tarr and Daniel Kelleher. Thank you.
Good afternoon. Welcome back from the break, board Secretary Tepper. I look forward to getting into the significant amount of edits that underwent 13. You may notice a specific distinction for 13, that it is a clean version rather than a red line version. That is for sake of being able to read it. There were a significant number of edits that were made, both functional as well as superficial, that were made to the document. In order to read it, the only way to read it would be to have accepted the majority of the edits. But we'll go over a lot of the edits and their main function as well as comments at this time. So I'm going to say skip 2 slides. This is just the background information that we had originally had regarding the application process. This is indicating that the baseline standards, which are currently being developed as part of the application guidance, is still under development as of right now. We are still creating the uniform set of baseline standard health, safety, and environmental standards. We have been collaborating with DOER in developing these baseline standards. That will be attachment 2 as part of the guidelines. Additionally, baseline standards have generally incorporated existing regulations and standards in effect, and we may have some additional unique standards that we're going to create as part of the EFSB. But those are still to come, so that's just a bit of a preview for right now. Let me go next slide. One of the main changes that has appeared in the regulations is the consolidated permit conditions, which are a significant point of emphasis that we'll probably talk about a lot today. So the board is permitted to include conditions in their final determination as part of their decision. We've recreated under 1309 the sources of these conditions so that it would be specific, that the board is aware that these conditions would be provided by the applicant, the permitting agency, party, or recommendations from staff members after a conditions conference is held. The point of the conditions conference is to sort of distill all of the common conditions and case-specific conditions that would be needed for any EFSB project that's being presented, and then a recommendation being made to the board following that conditions conference. So that's just a list of where all the different conditions would be provided to the board and where they would come from. So the presiding officer would then make a recommendation for permit conditions following that conditions conference. Then the permitting conditions would be incorporated into a final decision through board vote. And then we'll have some additional information regarding the specifics of how those are included or how those become part of a final decision and or a constructive approval. So some main themes that we had received from our comments regarding 13.0 were a lot of issues regarding timing. There was a lot of questions and requests for additional time on certain subjects, specifically additional time for commenting or intervention, or some lengthening or some quickening of the process so that smaller projects would be permitted in a faster fashion, or being able to reduce timeframes in certain sections. So there have been specific instances where we've included some edits that have indicated that the board is permitted to create a shorter time frame for specific projects if they so choose. As far as the written comment portion of it is concerned, or the intervention status, because of the tight time frame that we have for the review, we decided that it was not an appropriate thing to change at this time. So as of right now, it's 14 days. If there's some valid reason or some determination by the hearing officer, they would be permitted to change that timeline, as it's not set in stone, but there would need to be some kind of good cause shown to do so. Additionally, we also received a number of comments regarding zoning, which I'm sure everyone in this group is well aware. I think that Ms. Evans is going to talk about that a little bit more later on. But we did receive a number of comments regarding the inclusion of zoning as part of the EFSB consolidated permitting process. And as mentioned, there were a number of structural changes that had occurred as part of 13.0. One of the highlights or main changes that was made was the completeness determination, which was previously 13.09, is now been moved, and it's 1306, which then shifted 1307 and 1308 downward. That was for flow, as the completeness determination is the first part of the process before we get into any of the procedural steps regarding the review of the application and any of the substantive review. We also, one of the main highlights I want to indicate is that there's inclusion at the end of 13.01 for a defined term of guidance being defined at the end. It also is an indication that at any public meeting, this board would be permitted to make any modifications they felt were appropriate to guidance at any public meeting, so that that can be modified and changed so that if necessary, the board would have that option. We see guidance as a procedural safeguard for all of the steps that are included within the 13.0 regulations. So I'll just go through the comments that we have here. As I said, we had received a number of comments from a number of different groups, some positive. As indicated, they had requested additional intervention and public comment period. We indicated that there was no necessary change for that based on the controlled timeline. The completeness review has been specifically determined to be an administrative review. So we are going to be functionally looking for whether or not the applicant has included the specifics of the information, whether or not it is missing or not missing, rather than any type of substantive review. This doesn't preclude any of the permitting agencies from providing information regarding any of the contents of the permits that have been provided as part of the application. So they would still have the 21 days to review the permit that's been provided to them and the application process. And if they indicate that anything is missing, that would still require the permit or require the applicant to provide additional information in order to get a completeness review returned, or in order to receive a notice of completeness. One of the other comments that was made was regarding DOER application. We had originally incorporated that specifically as a requirement to include the DOER application in our application. We've decided to make that optional moving forward. So the applicant would be permitted, in the case of local zoning, to include a DOER application as defined by that local jurisdiction, or if not, then they would need to include the local permits that they would have been applying to through the local jurisdiction. Next slide. There was a number of comments regarding the DEP noise policy. We feel strongly on maintaining the DEP noise policy and did not recommend any changes. There were some questions regarding the noticed alternative. There's no requirement for the posting of a noticed alternative. However, the applicant would still need to describe, and we would need to verify if there was any clearly superior routes, and we would still maintain that level of review as part of the board, or as part of the board's review. The presiding officer will be providing a written response as part of the recommendations on permit conditions to the permit conditions provided by the permitting agencies as well as the parties as part of the process. That'll be in response to the conditions conference that will happen at the end of the evidentiary process. If the presiding officer does not directly resolve or describe the reason for any modifications or changes that could still be resolved through the board's recommendation or board statement as part of the final decision for any conditions that are to be included as part of the final EFSB consolidated permit. There was some discussion regarding the inclusion of prevailing wage. Labor provisions are part of DOER, so we had not recommended any additional change for that. There were requests to make improvements in the enforcement process. So under 1311, there were some requests that additional safeguards be put into place. We are going to add an additional portal online for the receipt of violations, and the director will be providing a response within 21 days for any request made by a permitting agency. There was also a request regarding the board to resolve disputes. Any and all permits or requirements that would be enforced by a permitting agency would still be resolved and handled by that permitting agency, as the board wouldn't have authority to resolve those matters, wouldn't have jurisdiction. There was a request regarding the timeline for the board as far as any specific delays. We have made sure that our process will be as transparent as possible through the dashboard so that anyone would be able to follow any delays in the proceeding and when any and all steps occur throughout the process, so that we didn't recommend any additional change. As stated, the environmental health safety standards will be established and attached as attachment 2 to the guidance. We did modify, there was a specific request for 1308 to be modified to include a shall, as the board is required to promulgate those standards. As far as the language access program, we feel that the language access program is best incorporated by reference so that if and when there are any changes made to the language access program, we are in compliance with those changes as they are detailed, rather than creating our own language access program that would be separate and apart. Next slide, please. So there are a number of sections that we had discussed whether or not they should be included in guidance versus included in the regulations. There are a number of topics that are resolved through detail provided in the guidance. So one thing would be the financial well-being of the institution that's applying for as an applicant. So the information that and the required information that would indicate that a company is reliable or has some experience in that sector would be provided as part of the application, but that information is detailed in guidance rather than directly through the regulations. As indicated, there are a lot of questions regarding common conditions. Those will be resolved more through 17.0, but there was a request that the common conditions not be one size fits all. We do have a number of different sections and categories for the common conditions based on the type of facility, size of, or potentially the type of size of facility, or any other additional thresholds that the board would like to set and establish. So it is by far not a one size fits all as far as the common conditions are concerned. They are separated out into different groups and sections. And one of the main other highlights that we have is that we added ministerial permits as previously discussed. Those are permits that would be required in a short time frame prior to construction of the project. So those would be handled and have been added as part for the director to issue as part of compliance filings. And we tried to make that as consistent with the DOER regulations as possible. We also received a number, next slide. We also received a number of comments regarding 13.0 guidance. Guidance is still under development, and I anticipate that we will be under development until we issue this and even afterwards in July. We did receive a number of helpful comments from a number of different people. We appreciate all of the detailed responses that we had received. I know there's a few commenters that we had received a number of comments about it and in very specific detail, and we do appreciate those. We updated them as much as possible. There is a red line version of the guidance that we have provided. A lot of the detail ends up being just specific to like environmental impacts and specific subsections, but as far as substantive changes, not significantly substantive changes at this time. I also want to highlight that there will be additional edits and such made based on the guidance for site suitability as well as CIA that will be added on as far as the guidance for that. So there is going to be additional modifications and changes being made. I look forward to additional board meetings where we may address functional fixes that we may need to incorporate, and we'll be happy that it's in guidance and not the regulations at that time. So if there's any additional questions, I'd love to hear them. Look forward to answering any questions from the board.
Thank you. Questions?
I have one related to 13.06 sub 3 related to incomplete applications. In subsection C, we discuss how permitting agencies have 21 days to identify deficiencies in a permit application. The language reads to me as if that 21 days starts upon receipt of notice of the permit as opposed to receipt of the permit application itself. I don't think that's the intent. I don't think we're intended to have to identify deficiencies based on a notice, not based on the application, but I just wanted to confirm that that is correct, that the permitting agency will have an application in hand, 21 days to review it and identify any deficiencies.
So it's my understanding that based on 1307 subsection 1 under filing, that the that the applicant would be filing these simultaneously. So the language was not intended to make a differentiation between the two. I would anticipate that the board would have the application at the same time as the filing is made. I also would have the understanding that the permitting agency through the pre-filing process would be well aware of any and all portions of the application already. So that this shouldn't be a new and surprise to the permitting agency that they're receiving this information. Ideally, there would be communication happening ahead of time. But that is not the intent. The intention is for it to be at the same time. It's not, I didn't intend a distinction in that section. We might be able to fix that so that it's more clear.
Yeah, maybe I agree with you that all of that pre-consultation, pre-filing consultation, all of that is very valuable. And I think that is the goal, right? That this will not be a surprise new application when it's received. I just think clarifying in this subsection, maybe it's just changing within 21 days of receipt of notice of a permit to receipt of notice or to receipt of a permit application for which they have subject matter jurisdiction, something like that, just to clarify so that everyone is clear on when this clock starts and can adhere to these timelines.
Yeah, I think that would be we can make that fix. Thank you.
Thank you.
Any other questions? Yes.
In 1303, I guess it's 1 sub K, the policies of the Commonwealth. I guess my question is, how does an applicant know what is relevant in terms of the list of policies of the Commonwealth?
That's a great question.
Nobody's known the answer to that for 25 years.
And I guess more to put a finer point on it, is that something that will be challenged by parties and become sort of a a wedge or a sort of a bludgeon to project applicants?
I think the anticipated plan is that as of right now, our current application includes a number of acts and other references to statutory compliance. Well, correction, it's now been modified to compliance. So it had been more in the spirit of before. So because the applicant is now going to need to comply with these specific acts, they would be aware of what acts they are dealing with directly, and they would provide us with at least some kind of brief detail, which they've already been providing previously before, like the Roadmap Act and a number of other acts, that they would just incorporate into the application. We don't want to, with the fear of end up requesting specific acts and specific statutes of an applicant, we would potentially be excluding them. So if they're aware of certain acts that they're triggering or coming into compliance with or not in compliance with, we would like them to provide that to us directly. And I'm sure that there will be a number of direct questions as part of information requests throughout the process to confirm that there aren't any additional violations or non-compliance as part of those filings. So, and this is also a specific requirement of the statute.
Right. The statute doesn't do us any favors.
Not at all.
Yeah.
And because it's a statutory requirement, we wanted to make sure that it was included in the regulations and spelled out so that we want the applicant to give a first crack at it. We will then provide if we have additional questions regarding specific statutes, we'll go into detail, and that can be throughout the substantive process rather than as part of the application process.
So in determining the completeness of the application, there will be a sort of, has the applicant looked at some degree of the Commonwealth's policies that would apply, and then that then gets further explored in the application review process. So it's not going to be a barrier to getting the sort of completeness of the application, as long as there's some reasonable attempt at looking at what policies are applicable.
I would say that's a fair characterization. At least a reasonable attempt at indicating whether or not or what level of compliance the project would be in at that point. And then there will be additional exploration through substantive review.
And over time, the siting division and the board will have a better body of evidence and better body of experience on which to sort of determine the reasonableness of that. Okay.
Yeah, absolutely.
Any other questions? Online? No? Okay, let's move on. Thank you.
Good afternoon, Daniel Kelleher, the Siting Division. So what Connor was just talking about, the 13 regulation is the standard process for consolidated permits. What I'm talking about is an aberration if things don't go according to schedule, and we're trying to avoid ever having to dive into the 17 regulations. But so constructive approval arises if the board doesn't issue a final decision within the statutory deadlines. And also, just to be clear, the constructive approval doesn't apply to de novo adjudications. It doesn't apply to non-clean energy projects. It only applies to the same projects that the consolidated permit process applied to. If we could go to the next slide, please. So there is a significant revision in the proposed regulations from what was presented back in September. And that has to do with the process by which common conditions are determined. So the statute provides that when a constructive approval permit issues, it will include common conditions and requirements established by the board through regulation, something like that. So this version of the regulation goes into more detail about how those common conditions are determined. And I think it's worth just explaining the two possible routes for it. So, and I think the terminology might still be evolving, but on the slide, there's a reference there to generic conditions. So there are generic conditions that might apply to all clean energy projects in general, or they might apply to specific types of projects within the clean energy area. And so those generic conditions, there's a provision in the 17 regulation that the presiding officer will have a conditions conference. We'll meet with the parties. We'll discuss proposed conditions, and part of that, the conditions that will be considered are those generic conditions. And the presiding officer and the others will examine, are those generic conditions good conditions for this project? Do they need to be tweaked somewhat? So ultimately, the presiding officer will recommend conditions that will attach in the event of a constructive approval. And the regulation provides that there will be a board meeting that will consider these proposed conditions, and that these proposed conditions will be subject to a consent agenda. Basically, does everyone agree or not? And if not everyone agrees, if I understand this correctly, then those proposed conditions aren't approved and they're not attached as the common conditions that go with the constructive approval, but rather any of the generic conditions that are applicable to this project are what end up attaching. So there's a mechanism that's provided in these revised regulations that provide for conditions that are tailored to the specific project. They require approval from the board for them to actually attach and be part of the constructive approval permit. Next slide, please. So that revision having to do with the common conditions is really a response to internal comments. There were a number of comments, external comments, and these next two slides discuss the external comments. There are basically three broad categories of comments. One had to do with expanded notice or expanded opportunities for public participation, public involvement. Another one had to do with areas, comments that really are better dealt with or are already dealt with by other regulations. And then the third category of comments are those that are addressed by these proposed revisions regarding common conditions. So for the first row, I would say that's a comment related to an increased public involvement. We agreed with that condition that and it's not even a condition, it was a request that the board release the proposed common conditions for review, and that's part of the plan. For the second one, that had to do with process and keeping people informed. It was requesting a review about whether a constructive approval is likely, and doing that every 60 days. We didn't think that was necessary. The presiding officer would have that discretion to do it, but we want to keep the presiding officer's time focused on actually processing the cases and not necessarily reviewing them. Also, as Connor mentioned, with the dashboard, there are ways for people to track the progress without the presiding officer going through the step of announcing it. For the third row, so it says that the constructive approval should reflect the board's statutory obligations in other areas. That comment is addressed through other regulations, whether it's through the 13 regulations or through the CIA regulations. These other regulations apply to the consolidated permits in the first instance. Number 4, this is a process comment, and it had to do with dissemination of the notice of likelihood of constructive approval. We agreed with that, so that proposed revision is incorporated into the regulations that we're presenting now. Next slide, please. The top condition having to do with the incorporation of conditions on a rolling basis, that comment seemed to be addressed towards making sure that the conditions are ultimately incorporated into the constructive approval permit. And the regulation as drafted now provides for a mechanism for ensuring that that happens. The second row. Yeah, that is also, that's an example where it's already addressed by another regulation. The third row has to do with public notice again, and with a lot of these having to do with increased notice. There's a balance between how much do we require of the presiding officer to go out of its way, and how much do we stipulate in advance that the presiding officer is required to do, rather than giving the presiding officer discretion to make that call on a case-by-case basis. And then the final comment there, the regulation should authorize the board to update the draft constructive approval. Oh, yes. Yeah, so that was a technical comment, and we agreed with that. And so now the draft regulation allows the presiding officer to update the draft constructive approval permit after the presiding officer has received comments on that draft. Are there questions from the board?
Okay. Thank you very much, Presiding Officer Kelleher. I want to make sure I understand the common conditions and the interplay for constructive approval. So my understanding is that the regulations as drafted now requires a conditions conference in all cases, correct?
That's correct.
And then if a presiding officer anticipates a constructive approval, they would then issue the notice of likelihood of constructive approval. That's under the 17.03 sub 2. And then they separately issue the recommended permit conditions and requirements, correct?
Correct.
Sorry, I'm just walking through my logic. Okay. So then there are opportunities for the parties to file comments and an updated version of the revised permit conditions and requirements that comes to the board for a vote, correct?
Yeah, I think the way that it's drafted right now requires just a little bit of tweaking, but I think that's consistent with what we're envisioning, what you just said. Except I think the way that it's drafted is that the board considers the permit, the conditions, and I don't know that it specifically says that it considers the draft constructive approval permit.
Okay, so I think there's a little tweaking of language that's needed. So the other point is we're saying that the board would make a decision through a consent agenda. And the reason we're saying there's no opportunity to debate the language is because we don't have enough information at that point, because we're only seeing sort of a portion of the project, right? Because it hasn't come before the board for us to fully consider. Is that accurate?
I'm going to have to ask our counsel.
Thank you, Mr. Kelleher. So the reason that it comes as a consent is that it does not come with a tentative decision, does not come with information on the project. Normally the constructive approval would just issue and you would just get the common conditions that are general attached to a project. We tried to come up with a mechanism to attach specific conditions to the project. This is the mechanism we came up with, is to have it go as a consent agenda item, basically an up or a down on whether or not to attach these in the board meeting before the time runs out and the constructive approval attaches or issues.
And I think that makes sense. And it is responsive to conversations the board has deliberated at earlier citing board meetings. So that makes sense. I will just note, I have some concern about how we manage this, or how staff manages making sure everything gets planned early enough to get on a board agenda, because there's going to be multiple, decisions coming before the board. And again, I just sort of note that this is going to be hard to manage, and we'll figure it out, but I'm registering that concern.
Just the one way that we envision this happening is my understanding, Director Green is already starting to plan monthly board meetings, and that's the way we're going to go forward in order to process all the material that needs to be processed from the new siting board. And we have a bigger board. We'll have a bigger board on March 1st. The plan was to have the recommended permit conditions come the board meeting before, when the constructive approval would happen by operation of law. It's possible that it might make sense to have it come 2 board meetings before, but we can discuss the timing of when those recommended permit conditions would get to the board for an up and down vote. I don't think that needs to be in the regulations themselves as to which board meeting would come in.
I think that's right. And then just based on your last response, so if it comes 2 board meetings before and it turns out that the staff is able to, so let's say it comes before the board for an up or down vote, the board gives a thumbs up, and then staff is able to draft a decision, and then it comes back before the board, I presume that the board could then modify conditions and is not held to its former decision of an upvote. Is that correct?
That would be correct. Matter of fact, I believe there's a provision in the regs that states that nothing about the constructive approval regs prevents the board from going all the way through and issuing a regular decision. Okay, thank you. But yes, I agree that the board would be able to, because the decision of the board made a decision on the conditions, but no decision has issued either by the board or by constructive approval yet. So if the board gets to an actual decision, it could attach modified conditions to that decision. Yes.
Thank you. I'm not sure it's entirely clear, all of the points that we just talked through, but I don't have recommended edits at the moment. Let me just think about it. I'm talking about 17.05, yeah. So I'm looking at 17.05 sub 2, talks about essentially if the board does not issue a final decision, then the, sort of upvote would apply, thank you. But it doesn't sort of say then the opposite is if for some reason the board is able to issue a final decision, it doesn't quite say what the last point about the board can then further modify conditions.
We can add that.
And just a quick follow on. So if the board does nothing, if the board doesn't meet or does not take a vote, the only conditions attached to a constructive approval are those that are the common conditions.
That's correct. The common conditions for that type of facility.
For this type, whether there's a storage project.
They'd be different for a T&D facility versus a battery facility.
Sure.
That type.
And then if the board were to accept the presiding officer's recommendations of additional specific conditions, it's an up or down vote for all the conditions recommended.
For purposes of the constructive approval.
Okay.
For purposes of a regular decision, the board's going to get a tentative decision with recommended conditions that will come out of the conditions conference, but the board then can deliberate, amend the tentative decision, amend the conditions, decide something different, and then vote.
And that's super helpful. And I think that the intent is, pretty clear. I got a little confused between number 1 and number 2 and whether, what happens with the non-common conditions or non. Thank you.
Thank you.
I'm all set. Thank you for bearing with me in my walkthrough.
Any other questions on the constructive approval section? No, thank you. Next, I would like to talk very briefly about 3 different, what we're calling, cross-cutting issues that don't deal with actually one particular regulation. I'm going to touch on the first one really quickly because we've talked about this repeatedly. We received additional comments on the zoning exemption provision. as a general matter, we heard from local communities, don't touch our zoning, that type of thing, don't override our zoning, leave our local authority. We've heard those comments all throughout. I believe DUR's heard some of those comments also. Then we also heard comments specifically on what the staff had included in the regulations regarding zoning exemptions. Specifically, staff had included an interpretation that zoning exemption filings were still necessary even under the act. We heard from Eversource and National Grid that they do not believe that that's correct, and they believe that the consolidated permit inherently includes zoning exemption. So when a consolidated permit is issued, all zoning would be exempted with that consolidated permit. We heard from Avangrid a little bit of a different proposal, or a slightly different proposal, that Avangrid agrees that the authority to grant zoning relief is in the consolidated permit, but stated that it might be helpful to also grant the zoning exemption under the existing zoning exemption statutes, kind of a both type of an approach that grants the zoning exemption under both types of authority. And so we added language, staff added language to the regulations that stated the board may grant zoning exemptions pursuant to either statutory authority. The way we did this was in order to ensure a robust decision. There is, I think, still some ambiguity or some difference of opinion on the extent of zoning exemption authority under consolidated permit. This way, when the board does grant a consolidated permit that includes zoning, the board would grant it under both authorities. And I think that greatly lowers the legal risk on appeal for those decisions. Yes, so that was just basically to cover our bases in both areas. We agreed with Avangrid's proposal, and we added language for that purpose.
So can I just ask a quick question on that while we're, so I just want to make sure I understand in the real world what the petitioner is supposed to do. So when the petitioner files for a consolidated permit, are they also supposed to file a separate petition for a zoning exemption, or is it all part of the same thing? It's a section in your petition for your consolidated permit. Is that how it works?
So they would file for zoning exemption authority under 40A, under the existing statute. Whether it's a separate petition or a separate section of the consolidated permit petition, we could probably figure out how to make it one document. As a practical matter, the presiding officer would consolidate the proceedings, so there's only one proceeding and only one decision. It would, which is what we do now, right?
So is the practice going to continue that in order to make a decision with respect to 40A Section 3, you would still need the evidence that you otherwise would need to make that decision, and you would have to make the findings that are required under that provision? So we're just going to continue to do it the way we do it today, basically.
Yes.
Okay.
I will note that the evidence for zoning exemption overlaps heavily with the evidence needed for a consolidated permit. There would be a lot of overlap. It's not a totally separate thing. I will note that.
But as a practical matter, when you're somebody who's writing your petition or your brief, you're going to want to go through each of the requirements with respect to 40A Section 3, as well as the requirements with respect to.
And there are, yes,
and so that the findings are made so that you're, okay.
The standard review includes 3 sections of findings. That's what we use in our 40A reviews right now. So the second cross-cutting issue I want to talk about is transition issues. We heard from a number of the clean energy developers looking for some clarity on some of the requirements during the transition. The first set of requirements had to do with the segmentation provision that's in section 1. I talked about it a little bit earlier. Offshore wind developers in particular were concerned about that segmentation provision and that and the fact that there are certain federal requirements and regional requirements that may require an offshore wind developer to phase a particular proceeding or particular project and do not want to run afoul of the segmentation provision. We added some flexibility to reflect that in the segmentation provision section, and hopefully we've addressed that there. The second cross-cutting issue that related to transition, we heard from some of the large battery developers. There is a provision in the Act under Section 114F that deals with battery facilities in particular. And F talks about when a battery facility developer has requested local permits, it is basically not required to get a start over and get a Section 69T review from the board. The battery developers were concerned that a number of their projects have long lead times and they are currently in development. They do not want to have to start the whole process over come July 1st. And so we agree that, at least staff's recommendation is that the battery developers request that we look at the requirements of requesting a local permit very broadly. We agree that that would be consistent with the Act and that they would need to request those local permits by March 1st and maybe even July 1st. There is some possibility that's July 1st. We want to deal with this a little bit more detail in the tentative decision. It does not go in the regulations, but we think the idea that the battery developers don't need to do things twice is consistent with the intents of the Act. And we agree with that. But again, this will be language that will show up in the TD, not in regulations, because it's a short time limited problem just during the transition.
Before we move on, Ms. Evans, I just wonder, given the timeline for when we'll get to a TD and the fact that if people need to do something by March 1st, they would need to be pretty far along on it now. Is there any thinking from the staff that you can share about the relative merits of March 1 versus July 1 so we can at least signal to folks where we think things are headed?
So the statute says, the Act says, request local permits. I'm not going to give you
fair enough. You don't have it memorized. Yeah.
Although that'd be kind of scary, wouldn't it? The Act says that the battery developers must request local permits by the time the board promulgates regulations under Section 132, which is March 1st, 2026. However, we're not promulgating all of our regulations by March 1st, 2026. We're promulgating some of them by May. That's the CIA regulation. So there is a little bit of flexibility there. It seems to us to make sense to give them until July 1st, 2026 to finish, to be the time where there's a cutoff for pursuing their permits locally and not having to come to us under Section 69T. I think the added argument in favor of that is we do not currently have jurisdiction over large battery systems except for under zoning exemptions. So therefore, we don't even have jurisdiction to issue permits for a large battery facility until July 1, 2026, when the consolidated permit program goes into effect. The Act says by the time we promulgate regulations, that's what it says under 132, and 132 says they're due on March 1st, 2026. But we're hoping to be able to maybe provide a little more flexibility there.
Okay. I would tend to agree that just logically speaking, unless and until there is a separate process that's actually in place for them to take advantage of, i.e. what will be in place as of July 1, they should be able to continue with the existing process. The goal is not to have people do things twice.
And we completely agree with that and have been signaling that we don't expect things to be done twice.
Great. Thank you.
Thank you. And the last cross-cutting issue I want to just talk about just very briefly is alignment with the DER consolidated local permit rules. As we know, while we've been developing our rules, DER has also been developing their rules. And as I said, they're ahead of us, so that's great. They've made a couple of changes to their rules that we're reflecting in our rules, and we're doing ongoing coordination between the two sets of rules so that we are in alignment. We note that DER's recent changes, although I found out it's been 60 days, which surprises me. That doesn't sound that recent, is to allow developers to choose either to go through the consolidated local permit program that DER's regulations set up, or to be able to choose to pursue local permits at the local level a la carte, individually. So that change has been reflected now in our rules. There's a couple things that fall out of that. And the first thing is that where a developer is seeking a consolidated state permit under 69V, and if it is not, if it is following the consolidated local permit process, it does pre-filing under the local consolidated permit process. But if it's choosing to pursue its regulations individually, then it would need to go through the EFSB pre-filing process because it won't go through the local process, the local pre-filing process under the DER rules. And secondly, that what falls out, I think we talked about briefly before, if a local developer pursues their local permits individually at the local level, they're not eligible to come then through 69W for de novo adjudication because they've not gone through the consolidated local process. So just we've adjusted our regs and then addressed kind of the fallout from those decisions, and we've put both of them in the regulations to make it clear.
Any questions about that?
That is what I have. We have a very brief update on the Department of Public Utility rules, rulemakings. And Vina, did you want to address those or would you like? Oh, okay. Correct me if I'm wrong, please. So the Department of Public Utilities have two rulemakings going. The first rulemaking is they are setting application fees for EFSB application fees. That's the way the statute's laid out, is that Department of Public Utilities sets those fees. Those fees have been drafted. I believe they're in interagency review right now. We've worked closely with the DPU staff to establish what might be, what are reasonable fees. And the DPU will issue order opening the rulemaking with the rules attached shortly. I don't have an exact date, but shortly. Yes. Secondly, the intervenor support grant program regulations are also drafted by the Department of Public Utilities. Those went through the hearing process with the EFSB rules. So you've seen the rules. They've already been proposed. Their comment period is closed. Changes have been made to those rules in response to the comments, and those rules will be promulgated, I believe, by March 1st, 2026, along with EFSB rules. So that's a quick update on those two sets of rules. If no one has any further questions, perhaps we want to go now to the public comment period process.
I'm thinking maybe we should take a break and then go to the public comment process. So it's 3:30 now, so we'll come back for our public comments at 3:40. Thank you. Okay, thank you. Back on the record. We're now ready to take public comments, and we are asking that people keep their comments to 3 minutes per speaker. We have a fair amount of people we think that want to talk, so we appreciate that people keep their comments to a reasonable time. For those of you who are on Zoom, if you could unmute your microphone and turn on your camera if you like, and state and spell your last name for the stenographer. And just a reminder that we are taking down with a stenographer what people are saying, so you have to talk slowly and clearly. As I mentioned, we're going to begin with public officials, and then we will go to members of the Commission on Siting and Infrastructure, and then the Siting Practitioner Advisory Group, and then the task force members, and then the general public. So we will start with, are there any public officials who would like to speak this afternoon?
We have Lori Degnan from the Charlton Planning Board.
Thank you. Okay.
Oh, there I am. Hi.
Hi.
Hi, Lori Degnan, Degnan, and I'm a member of the Charlton Planning Board. I have a couple questions. First one regarding Section 13. When and how will the municipality be notified of a pre-filing and/or of any waiver request? And then the second question is under 1303(1-L. You mentioned the decommissioning and site restoration plan. It's a pretty brief paragraph, but there's no mention of mandating any financial surety in case a project for decommissioning, in case something happens with the project. Like we're requiring decommissioning bonds in Charlton. So it would be nice if it was listed under 1303, if it's possible. Thank you.
Yeah, thank you for those questions. Does the staff want to say anything to help out here?
Yeah, sorry. I know you had a question about when you would receive notice about outreach. My expectation is that one of the first entities that a proposed applicant would reach out to would be a municipality in which they would propose to locate a facility. So my expectation is that you would receive notice of that intent at a very early stage, long before an application is finally filed with the siting board.
So a consolidated permit, we would be privy to that prior to the EFSB?
No, I thought you were asking about an application in general. If it's a consolidated permit, I think Connor can address that question. Sorry.
Yeah. Well, I'm talking about the large projects, which I believe do fall under EFSB as opposed to the DPU, right?
That's right. Yeah,
Okay.
we can answer that question.
Thank you.
Yes. If there would be a request for any type of local permitting that would have gone through the local government, you as the local government should receive notice at the same time as the filing of the application, if not sooner than that. So as part of the pre-filing process, there should be some type of outreach beforehand. If not, you would at least receive what would have been the application as far as the permit that they are requesting, essentially as a courtesy copy that you are being made aware that a permit is being requested from the EFSB that you would have jurisdiction over.
Okay. Well, I'm sure you can you can understand why I worry about the word should. But I hope that happens. Thank you.
Let me correct myself. You are required to receive a concurrent filing at the same time as the EFSB, and that will be received simultaneously. That is a requirement of the regulations. Pardon my language at this point.
Okay, thank you.
As far as the surety point goes, the decommissioning and restoration plan is also part of 1.0 and has been added or 980 CMR 1.0. It's 1.10 or 1.10 decommissioning site and restoration plan. That's at least to be included as part of the application. As far as the requirements go regarding a decommissioning plan, that could be part of a condition as far as the surety. That wouldn't necessarily need to be included as part of the application itself on the front end. So if it were to be approved, there may be a requirement that a surety bond would need to be issued prior to the issuance of a consolidated permit. But that would be a condition that would be placed upon the company as part of a grant of the consolidated permit. So that would happen at the end of the process, not the beginning. So the decommissioning plan that you're seeing within 13.0, the section that you referenced, 1305, would be specific to what does the company plan at this point at the beginning of the design process? How are they planning on decommissioning the project? I know that utilities end up doing it a lot differently than a private sector would end up doing it based on projected life of the facility and potential upgrades to the facility. So that's where it ends up getting into a bit of a murky area, but I believe that we would end up having it as part of it could be part of the conditions, and we would encourage the local government as a permitting agency to be included in the process and then provide that as a recommended permit condition as part of the application process that would be included in the final EFSB consolidated permit. I know that was a lot.
Yeah.
Is there any more that I can clarify?
I guess going back to the attorney who kept mentioning these parts of this big bill aligning with one another. And I think this is one point that it should align. Just because we're a small board, we believe everyone that comes before us, and they would say, oh, it's not under 1303. So is it attainable? They shall provide a decommissioning bond because we don't know this. It's so new.
So this is Joan Evans. So as Connor mentioned, the decommissioning plan shows up in our 1.10 regulations. It requires a description of different parts of the decommissioning plan, including a description of any financial instrument to ensure decommissioning and restoration activities. That would be filed with the application with the board. Determine whether additional conditions were added to the project approval should the board approve that project. The regulations at this point do not require a decommissioning bond.
Okay, disappointing, but thank you for explaining it. Thank you.
Thank you very much for your comments and for joining us today.
Thank you.
The next person we have is Jackie Quarry, who is a select board member in Blandford.
Yes.
We can see you.
Hello?
Hi.
Oh, hi. Sorry, I just wanted to put my phone on because I know I got 3 minutes.
You're perfect.
This is Jackie Cora. I'm with the Blandford Select Board, and my background was VP of Operations for a couple of businesses before I moved up here to Blandford. But I wanted to give you some of the practical feedback that has occurred here in Blandford, so you understand what the town's going through. So bottom line, one of the things, we've had a number of vendors come through here, including Eversource, that keeps reflecting on a plan. Everyone that has come through, I've asked, what is this plan that you're referring to? And they say it's from the DPU. If there is a plan for energy implementations throughout the Western region, it would be great if the DPU would share that. If there is no plan, then it's taking each one of these one at a time to try to figure out what's happening as we expand in Blandford. So I would appreciate, I'll probably write a letter about the same thing, but I'm just curious as to what this plan is. They're all pointing to DPU. As far as the small towns are concerned, Blandford is around a $5 million budget with, half of that going to the regional school district. And all of our boards and commissions and committees are volunteer only. So please be cognizant of that when you're executing on this. We've had a number of people already quit because it's just been overwhelming, because we happen to have an Eversource expansion going on. So more and more of these vendors are wanting to come into this town. A couple of things, and I don't know whether or not you guys are aware of all this, but I just want you to be aware because it's going to be an execution problem. The towns have not been, I'd like to understand also who is responsible for ensuring these towns have the ability to handle emergencies. A lot of the small towns in this area do not have the infrastructure, nor the water, nor the fire departments. And I know just from really watching you guys that there's a ton of people that feel that there's no need to be concerned about safety, but it is one of the number one challenges or concerns that the townspeople have. We need to address it. I'm going to run out of time. So obviously there are a number of things, and I'll write them in a different letter, but I wanted to at least discuss the safety issues because I've looked at the data myself. And quite frankly, I think the data is suspect because the volume is coming in high and the percent of defects are not showing up. The last thing is there's nothing in here about vetting these vendors. We have a number of vendors that have come through and they have zero experience on this, zero. And no one is reviewing these vendors to make sure that they're even capable of doing these things in a safe manner, especially the best applications. So I'm just not sure where the state sits with all that. I know it's not in your purview. You're on the purview of we need to get these things out there and running, but there are things that the towns are dealing with that frankly, we don't have the money to deal with. And we don't have it's not just the money, it's the resources. So I'm just asking, have you guys discussed any of these issues?
Well, first of all, I'd just like to say thank you very much for joining us this afternoon and giving us the on-the-ground information that you have and the real-world information that you are experiencing there in your town. I do appreciate the fact that people are taking time out of their day to talk to us about this, and particularly the written comments are very helpful because it gives us an opportunity really to sort of ponder and think about it. And really see how it relates to the regulations and the things that we're doing. So, thank you for the written comments as well. I would say that one of the main purposes of having some of these facilities being reviewed by the Energy Facility Siting Board is to get to exactly the kind of issues that you're talking about. You want somebody who is an independent person who is taking in all the evidence and being fair and based on the evidence that's presented in a matter to make a decision that whether something is safe and whether it's going to be an appropriate project for that particular area. So I think the kinds of issues that you are talking about are the exact kind of issues that should be looked at in a proceeding at the Energy Facility Siting Board.
And just to share, the reality of it is in real life here is that some of these guys that are doing the secondary reviews are also working for the vendors. So you feel like you have no one really that's supporting the residents, right, in the town. So we're running across that because of the volume.
I see.
Right. So it's just really important to get the real, day-to-day feedback as to what is truly occurring. Because if you guys want to execute on this, you're going to need the support.
Yes,
right?
Yes, completely. And I mean, one of the things that's new in this legislation is having the Department of Energy Resources really having a good communication with municipalities about these issues. I mean, that we now have a new division that is particularly designed to help municipalities work through this process, because we know that there are, particularly with smaller towns, there's some need for additional assistance in sort of working through these issues.
Right. Okay. All right. I just, was curious to see what we're doing about these types of things that are kind of outside of what you have here in your, regulations.
Appreciate that. Thank you very much.
The next person we have is Michael De Chiara from the Shutesbury Planning Board. I'm going to demote Ms. Corey.
Can you guys hear me?
We can.
Great. My apologies if you've addressed this earlier. This is, I think, the first meeting I've missed. I wasn't able to attend for about 20 minutes ago. As some of you know, I think I've commented on every proposed regulation that's been out there, trying to be engaged and provide the on-the-ground feedback. The request I have, which I did email yesterday, is I would ask that the board extend the public comment deadline beyond Friday. The proposed changes and regulations were posted at 6:23 last night. 2.5 days to look these over, actually think about them and get them to you on Friday is pretty much an impossibility if you're trying to do it. So if you want feedback, at least give us a week. 2 weeks, I think, is more of a norm. I recognize that you're in a tight deadline and you're trying to hit March 1st, but if we're going to have a back and forth process with actual feedback, I would request that you extend the deadline. And if you discussed it previously, my apologies.
Hi, Michael. Nice to see you. I guess the first thing I would say is appreciate your comments, and I did read your email before coming today. I mean, one thing that I would note is that this particular process has included a lot of public comment, much more than is required by statute, much more than typically would be done. This comment period that we're talking about right now is not a comment period that normally would happen. This is an extra comment period that the board has allowed. That being said, I think we should think about your request, and we'll think about that and get back to you on it.
Great. And I would just say, I mean, to your point, you guys have been great. I mean, you've been above and beyond with the straw polls and the feedback. So the short period of time is actually the anomaly here. But I think the state has really been good and engaged, and those of us on the ground who are trying to work as partners on this. So I commend you all for that. I'd like to see the spirit go forward. Thanks again.
Understood. Okay.
We have someone whose name is Robert, and I don't know if you are a public official. If you are, if you're not, please lower your hand and we will call on you during the public period. I've promoted Robert.
Robert, do you have a comment? Okay, maybe we can get back to Robert. We're not being able to hear him right now, so why don't we try the next person?
So we have exhausted the people that have had their hands raised. Maybe, Madam Chair, if you want to call for the wider.
Sure. Yes. So do we have anybody who participated in the citing commission or the practitioners group that wants to talk? Yes, we have somebody in the room.
I'll have Jess Robertson on deck after
okay.
In person.
Okay.
Speaker.
Good afternoon.
Good afternoon. Deidre Matthews, National Grid, member of the CEISP. Didn't actually have prepared comments today, but after listening to everything, I wanted to get up and say two things. The first one is thank you, thank you, thank you. You folks have listened to us. You've considered everything that we had to say. You've been responsive. You've come up with unique ways of addressing issues, and we really, really appreciate it. Second thing is, that said, we hope you will respond to a final appeal on the constructive approval language that was just floated yesterday at 6:30. Don't usually mention this, but I am a former director of the siting board, and I'm scratching my head trying to understand how this new language is consistent with the spirit of the statute, maybe with the actual language of the statute and how you're going to implement it practically. I think the concept of a constructive approval as the CEISP recommended it and as the legislature adopted it was that if the board is unable to complete a review, then the project is approved with the common conditions that were in effect at the time of the application was filed. From a purely practical standpoint, I'm scratching my head a little bit on how you get to a set of common conditions and how the board adopts those common conditions on a consent agenda without presumably knowing whether the applicant thinks the conditions are acceptable or even physically possible. And I don't see how you discuss that on a consent agenda without taking it off the consent agenda. So I suppose there's a situation where the hearing officer could come to the board and say, we had this conditions conference, everybody agreed on everything. Here are their signatures. Feel free to adopt, but beyond that, I think you're deliberating. I don't think you can call it a consent agenda. Like I said, this is my former board director hat. I think this needs some more tweaks. And I think that council will address that a bit later. We will certainly be addressing it on Friday. It needs more work. And I don't want this to be a downer because you guys have been so great. And I am so happy with the way you have listened to us, and I hope you will listen again.
Well, thank you so much. And it's always an honor to hear from a former director of the siting board, speaking as a former director of the siting board as well. Yeah, I hear you on that. And thank you, number one, for thanking this great team who has done a terrific job. You know, as everybody knows, there has been a tremendous amount of interest in this, and this team has gone through every single line of every single comment and really thought thoughtfully about it. And if anybody was ever concerned about government caring about it, this is a team that has worked and really cares about getting this right. So we will take your comments under consideration, and I look forward to seeing the written comments as well. All right, who is next?
Jessica Robertson from New Leaf.
Hi, everyone. Sorry I'm not there with you in person. I'm a bit under the weather today. Thank you for all of the work that's gone into this. I'm very aware that everyone's been pulling a lot of late nights and really racing to the finish line. So I appreciate all the hard work. And overall, this is a mountain of regulations that are really in very good shape. I just wanted to flag one issue which we've previously raised in our comments, which is that the definition of key stakeholder. And so we had previously commented that it was overly broad and not very well defined, and the red lines seem to have made it perhaps a little bit broader still. And so I think we are all, you know, on board with doing really good engagement and making sure we are engaging with all of the people who are important stakeholders in a project. I think it's just, we need a little bit more clarity on who decides who is a key stakeholder, because what we have is a list of types of people who are potentially a key are the relevant ones for that project. So just hoping we can try and make that a little bit clearer in terms of how we get to a mutually agreed upon list of key stakeholders, because there are other places. I'm looking at the pre-filing engagement regulations, and there's many references to key stakeholders in terms of you have to have meetings with them, you have to document the things that they care about and how you've responded to them, et cetera. And so if there's a lack of clarity about who counts as a key stakeholder, that could lead to a lot of confusion.
Thank you very much. Jessica, are you planning on providing some proposed language along those lines, or are you thinking that we should just think about this a little bit more?
I don't have a proposed edit at this very second,
That's fine.
but you could come up with something in writing.
No, I'm not saying you have to. I was just curious about whether you'd be providing something in writing along those lines.
Yeah, we can for sure.
Okay, great. Thank you.
Thanks.
So Robert has re-raised his hand, but I don't believe Robert is a person in the commission. So,
okay.
Do you want to take his comment anyway?
Why don't we try to talk to Robert?
Okay.
So Robert, you're up.
He's rejoining as a panelist.
Okay, thank you. My comment is, this is the Energy Facility Siting Board, but it sounds like it's more like
Robert,
the energy.
can I just interrupt you for 1 second? Can you please tell us your full name and your who you're associated with?
I'm sorry, Robert Cherdak, Ashfield Planning Board.
Thank you.
And
please proceed.
Comment is, you are the Energy Facility Siting Board, but what I see you as is the Energy Facility Permitting Board. It seems to me that in order to expand the electrical generation and distribution system in this state, we need a coordinated plan. People need to know where the generation is in order to decide how to best transport the power via transmission system. On the other hand, people have to know where the transmission system is to find the best place to put a generation facility. It seems to me that there should be a coordinated plan going on between this facility. Right now, the utilities are doing their modernization plans, but you're still waiting for applicants for the generation companies. It seems to me that the site for a facility, for a generation facility, should be determined as well or in coordination with developing the transmission system. We shouldn't be waiting for individual entrepreneurs to be coming to us, or coming to you rather, for permission to site a plant somewhere, which might be in conflict with the transmission plans being developed by the utilities. It seems that a coordinated, you folks have the resources between the DOER, the DPU, and the utilities and ISO New England. You folks have the ability and the talent to create a siting plan and a distribution plan and transmission plan that will provide the robust doubling, I guess, of the energy generation and transmission in the state. And waiting for individual entrepreneurs, some of whom are not particularly experienced, to step forward with a proposal for a generation site, I don't think will lead to the optimum system that we really should get to as part of this process.
Thank you, Robert, for those comments. Appreciate it.
You're welcome. And I do appreciate the amount of work you've done. Just reviewing what you feel have done is exhausting. So creating it must have been really exhausting.
Fair enough. All right.
So again, thank you.
Thank you for your time.
We have Jackie Corey who raised her hand again. I don't know if, Madam Chair, if you want to go through some new folks first.
Jackie, if you don't mind, we're going to go through, give everybody a chance before we go back to people.
Even though she's the only one with her hand raised at the moment.
Okay, well, do we have anybody else from anybody else from the group who participated? Yeah, Mr. Rosenzweig.
Thank you and good afternoon, Chair Tepper, board members, staff. My name is David Rosenzweig. I was a member of the Siting Practitioners Advisory Group, and I'm appearing today on behalf of Eversource Energy and National Grid. At the outset, I want to echo what Deidre Matthews said about the extraordinary work that's been done by the staff and their diligence and hard work throughout the process. The companies really sincerely appreciate the efforts of the staff and the siting board and the EEA for the numerous avenues that have been provided for public input throughout the process. It's clear that the siting board and staff and EEA and all involved have closely considered the input that they received to date from the companies and a wide array of stakeholders. And based on an initial review of those revised regulations, many important refinements and improvements have been incorporated. I want to express my general support for the changes that have been made to the draft regulations and urge for perhaps in one or two areas for further refinements and consideration. As the company stated in their written comments, the companies believe there were a handful of top-line issues at that time that required further clarification and revision to ensure that the siting board's regulations properly implement the primary purpose of the 2024 Climate Act to streamline the permitting of new energy facilities, clean energy infrastructure in affordable, efficient, and equitable manner. Those issues relating to zoning, completeness determinations, segmentation, the interaction of the siting boards and the DOER's regulations, and the treatment of noticed alternative routes and sites for clean energy infrastructure were top on our list at that time. The companies appreciate the revisions that were made on each of those topics regarding zoning, completeness determination, segmentation, and the interaction of the board and DOER's regulations. We fully agree with the revised rule at 980 CMR 13.041, which now recognizes that the siting board has the statutory authority to grant zoning exemptions under Chapter 164, Sections 69T through 69V. The changes are based on a proper interpretation of the relevant statutes and will greatly facilitate the one-stop consolidated process for the Climate Act without challenges, without appeals, and in an efficient and orderly manner. The companies also appreciate the revised regulations at 980 CMR 13.061E that a completeness determination is intended to be an administrative determination in nature and not as a preliminary assessment of the merits of the company's application. That's the purpose of the siting board's 15-month review process with the participation of all parties in the adjudicatory process. Given the importance of the completeness determination, starting the clock for the 15-month review, having clarity on that issue is very, very critical to the process. Similarly, the companies appreciate the new language in the segmentation regulation that shows greater flexibility that the project segmentation rule will be applied on a case-by-case basis with due consideration of the integrated nature for the utilities purposes of their integrated utility grids, where there's so many facilities that are connected to one another, and there are a myriad of needs that be met over time, and it's very difficult to discretely chop that up into pieces without running into the question of whether segmentation is occurring. I think the flexibility accorded under the regulation and in the guidance materials is appropriate and should stand. One remaining topic that I want to highlight is the issue of whether the applicant must present a noticed alternative route as part of its Section 69T application. First of all, the Climate Act provides no such requirement, and the Siting Board's draft rules also provide no such requirement, which is totally acceptable to the companies. There may be opportunities where a noticed alternative is appropriate to deal with some issues about workarounds or things that develop as construction ensues, but categorically there should be no general requirement to provide a noticed alternative site or route for a project. Certainly the companies will have to demonstrate, like all applicants, that they've reviewed available routes, sites, and alternatives and supported those. But the problem that arises now is that under the Siting Board's regulation at 980 CMR 13.03 2D, the last sentence of that regulation says that the siting and routing alternative analysis needs to conform to the guidance materials that the Siting Board has provided. At present, the guidance materials contemplate, and they have a sentence, that in general, the applicant must provide a noticed alternative site or route. I think that may have been an oversight. Certainly, we believe that it should sync up with the statute and the rule itself, maybe inadvertent. But from our perspective, as the Siting Board has recognized on prior occasions, a notice alternative route or site is not warranted in all instances, and we think that the rules and the guidance material should consistently reflect that fact. On the issue that Ms. Matthews just presented regarding the constructive approval, I certainly agree that there are problems in the way that the draft regulations have been revised to include a new process for beyond the common conditions, project-specific conditions that would apply to a constructive approval, and that those additional conditions would be presented to the Siting Board in a consent, action by consent. The process itself is an adjudicatory process. Parties have a right. There are issues that the Siting Board wouldn't have the evidence in the record before it as to the merits and reasonableness of those proposed conditions. Parties will have interests regarding whether they believe those additional conditions are appropriate. They need to have an opportunity in a forum to present evidence to support whatever conditions are being imposed beyond the common conditions. So we think there's some due process issues and procedural issues that are really serious in nature that need to be revisited before those regulations become final on the additional conditions for the constructive approval. I think the intent for the legislation with the constructive approval was that there was a disincentive, frankly, on all parties, including the Siting Board, to get sort of a bite at the apple, if you will, if it couldn't make a decision within the 15-month period, and all parties had to proceed within that process to adjudicate the issues, and then a record would be developed and a decision would be made. In the absence of that, the company's application, along with the common conditions, would apply. That's the way I read the statute. That's the way I think the words in the statute play out, and that certainly makes sense. And the due process issues of a sort of a secondary process down the road where parties may be subject, applicants may be subject to an additional set of conditions that haven't been fully adjudicated or wouldn't have rights to defend their positions seems inappropriate at this stage. So with that, I will close. We intend to file written comments on all these issues, and we greatly appreciate your attention to all these issues throughout the process. Thank you.
Thank you very much.
So at the moment, Ms. Corey is the only person with her hand still raised. However, she's emailed.
Oh, we have one more person here.
But Ms. Corey has indicated to me that she would send written comments instead of talking again. So
Great. Thank you, Ms. Corey. Appreciate it.
Thank you so much for this opportunity to address you again and for all the changes, all the work that's gone into these regulations. My name is Deidre Buckley. I'm the Director of Siting for Eversource Energy. I might say a lot of what David just said, but it'll be a little more brief and use common words. And no, I'm just kidding. So just, again.
It's paid by the hour.
What's that? So much progress has been made. And again, really appreciate it. We think a lot of the changes make sense, and can't say more about how hard people have been working. Everyone, I mean, from stakeholders who have become, there are people who come to every single meeting, from all over the state, which is amazing. Certainly the staff, DOER, EEA agencies, everyone's really been doing their all to get this done, and you're really made a ton of progress, and I think we're in such a great shape for these regulations. From the beginning, essentially we built a effective, comprehensive process that's going to build in community stakeholder engagement from the beginning, and towards the end of completely through the entire process, and includes flexible permitting pathways so that developers, all kinds of developers, have different approaches they can use depending on the community they're in, the project that's being proposed. There will be very clear opportunities for people to participate. You won't be wondering, oh, when are they going to give me that opportunity to comment on this? When will an EFSB meeting be? We'll know these things in advance. It's a compressed timeline, but it's one that's efficient and will help people make decisions instead of having, a lot of processes going on over years. This will be happening within 15 months maximum, which can be intense. It's going to be an intense process. It's going to take a lot of work. And for speaking for Eversource, the onus is really on us to provide clear, comprehensive, cohesive applications that include address all the requirements that we need to address in our applications, and provide state agencies and municipalities what they need in order to approve projects, and to work with them before applying for these projects to ensure that we understand those requirements, can discuss any challenges. And when we come to the siting board, we'll have a project that's ready to be reviewed. There'll be ample opportunity to address outstanding issues through discovery. And in the end, we'll have a clear deadline for a decision. So I think that this is really, really consistent with what was set out by the commission, as well as the recommendations of the commission and the statute. So this whole process to date, where we are today, I think the process is very well defended against any appeals. The regulations are consistent with the statute, and that will give us a very strong footing moving forward. Also want to note that, so there are a couple outstanding concerns that have been addressed. So segmentation is one of those. We appreciate the changes, very helpful. The utility network, you don't see it as much. Some people don't see, there's a lot of our infrastructure is underground, but it really is an integrated network. It's very similar to roadways and highways. And where do you draw a line when you're reviewing a roadway project? It includes sometimes asset condition projects, as well as new projects that provide new capacity. And that's similar to what we do as a utility. And so there needs to be some flexibility. And so the language is broad, but being able to look at it within the context of a utility that is a complicated network will be very helpful. So we appreciate including that language. In addition, on the constructive approval, as David mentioned, that the point of that was to ensure that we're making decisions on a time frame. And our understanding is a constructive approval means a decision was not made and the project will proceed with common conditions. So I also have questions, about what that process would look like. And I'm concerned that the board might be spending time working on common conditions or doing consent, meeting to talk about additional conditions on a constructive approval rather than working on projects that are in front of them that need to, where you still need to meet deadlines for those projects. So concerned about how that process would work and that it is not consistent with the purpose of the constructive approval. So I, again, appreciate your time. Really pleased to see where we are and look forward to seeing those final regulations. Thank you.
Thank you very much.
There's no hands raised.
No hands. Okay, so members of the public, or does anybody from the public want to speak?
Rebecca Behrens, I'm going to promote her. And then after that, we have Melissa Kaplan.
Okay. Ms. Behrens, you're up?
Hi there, can you guys hear me?
We can.
Thank you. And let me turn my video on as well.
No, this is Ms. Behrens.
Hi there. My name is Rebecca Behrens. Behrens is Behrens. I'm the Director of Policy and Market Development for Flatiron Energy. Flatiron Energy is a transmission scale storage developer, really committed to storage development in the Northeast, and with a pretty large portfolio of projects that we are undergoing the permitting process locally for. We are supportive of the draft regulations and really, really appreciative of the work that staff and the board have put into developing these regulations. I think whoever said earlier that it's a lot to read, and truly, I think shows that it's a lot more to write. So really appreciate that. I wanted to specifically call out Flatiron's strong support for the board issuing a clarification on the transition issue raised by Ms. Evans earlier in the presentation as part of the tentative decision. So Flatiron has several projects that we have spent a significant amount of time with the intent to permit locally in Massachusetts. And we are really committed to continuing that path as led by the Climate Act. And I think just the clarifications on exactly what that looks like, just to be really clear, both for us and also for the communities, would be really helpful. And I think the staff recommendations, as outlined earlier, do that well. And specifically as part of that, just clarification on like what exactly a permit is, and that something like a wetlands delineation does constitute just clearly starting the permitting process with the town. That's just really helpful, I think, again, both for us and the community, so that we don't have to restart a process that we're already undergoing on July 1st. So thank you again for all your work on this. Really, really appreciate it.
Thank you, Ms. Behrens.
I've promoted Melissa Kaplan to the panel.
Ms. Kaplan, when you're ready.
Sorry, took me a minute to get on. Good evening. I'm Melissa Kaplan. I'm the license and permitting team lead with the BSC group. I greatly appreciate all the time and effort that has gone into this and all the opportunities for public comment and input. And as someone who's very familiar with permit streamlining, I could acknowledge how much work has been put into this. But my question is I wanted to get some additional clarification on the consolidated state permit. First, in regards to the notice of intent under the Wetlands Protection Act. The DOER recently presented at an event that they are pulling out the NOI order of conditions NOI from the local consolidated permit, since the 12-month review period cannot be met within the timelines of the Wetlands Protection Act. I haven't heard if this was officially included in the DOER local consolidated permitting regulation or guidance updates, but I wanted to understand how these timelines would work under the EFSB large project consolidated state permit, given these same timeline constraints of the Wetlands Protection Act. Is the Wetland Protection Act permitting included in the consolidated state permit application, and will it be approved and issued in the 15 months? In addition, I wanted to confirm, as I think indicated today, that the consolidated state permit will not include the 401 water quality cert, CZM, and other federally delegated permits. With that, and then those permits would then need to be obtained separately within their typical regulatory timelines. Thank you.
Does staff want to answer the question, or do you want me to give it a try? Up to you. So my understanding is that yes, the wetlands permits would be part of the consolidated permit, and the federal permits would go on their own course. If anybody wants to correct me, they can.
Not correct. Yes, that would be correct. I would say that we discussed the federally delegated permits a little bit earlier, and whether we want to actually list what's the board has the authority to decide which federally delegated permits could be included. And we have not established a process to do that, but we could establish a process to do that. I think, given the timelines on some of these federally delegated permits, such as the 401 permit, it's likely that those would not be included in the consolidated permit.
Okay, any other members of the public who'd like to speak this evening? Here we go, in the room.
Thank you, Secretary Tepper. My name is Nathan Rake. Last name is spelled Raike. I'm the manager of state and local affairs at Renew Northeast. Renew supports the staff proposal clarification that existing CEIF may continue local permitting where local permitting requests were made by March 1st, 2026. And we also support Commissioner Heipel's assumption that continuing through July 1st, 2026 would also be feasible when there's as we are continuing through this process. This provides important certainty for projects that have entered a good faith engagement with local communities and allows these projects to move forward expeditiously. We also support the added definition of the definition of license in 980 CMR 1.0 and the case-based provisions for project segmentation review. Finally, we appreciate all of staff's hard work and dedication and reading through all of our extensive comments. Thank you.
I've promoted State Representative John Marcy to the panel.
Good afternoon. Thanks for joining us. We can't hear you, though. I think you might be on mute.
I am on mute. Thank you. Thank you so much, everybody. I just found out about this meeting about 2 o'clock today. So finished the call and I just wanted to jump on and, thank everybody for all the work on this and but also advocate a little bit for my towns, particularly Charlton. I live in Charlton. We have an overcapacity of, electricity that we produce, via solar and such. And the residents are really telling me, that, please let the towns decide what they want to be. Right. So if there's some sort of like exception process, that gets put into these regulations or, I know we're trying to make it easier to do these things, but, let the town decide. Having a heavy hand from the state is only going to make things worse, I think, for our towns out here. So I just felt compelled to join today to say that. Remember our towns and keeping their character.
Thank you very much. We appreciate that and your advocacy on behalf of your towns.
Thank you.
Anyone else would like to speak today?
There's Mike Hugo, who represents the Massachusetts Association of Health Boards.
Okay, Mr. Hugo.
And here we go. Thank you very much. Thank you for including me today and giving the opportunity to speak. I had not prepared anything. I was not going to speak, but Commissioner Heipel knows me better than that to expect me not to. I need to put in a word for local, the term local governments, and local governments, I hope, are inclusive of the boards of health in all of the regulatory process and all of the regulatory considerations that you're doing. The boards of health right now are fighting a battle involving the battery energy storage systems mostly. I'm spending probably 80% of my time right now, as I have been for the past 2 months, on BESS facility issues. Boards of health are concerned with the placement near aquifers, near town wells, near drinking water supplies, the inability for them to come up with suitable emergency responses where we have at least one or two proposals where there's literally no way to get a fire truck or an ambulance, and especially if there is an ambulance going in one direction and a fire truck in the other down the access roads that are planned. So boards of health should be considered from day one when the regulators, and I'm glad to see right now how many regulators there are and how many people there are from the industry that are attending today. And I want to get the word out to them that we don't want to be in a position where a board of health steps in after the planning, zoning, select boards, the mayors, the town managers are all looking at their pilot funding. And the Board of Health steps in and says, no, you can't do that. We'd rather be at the table from day one and have that frank decision or discussion that is inevitable and will happen at some point in every one of these applications, where public health has got to be on the table. And I know the statute, and I know that all of the various state commissions looking at this have been extremely respectful of public health and local public health. And I want to thank you for that. And I do want to thank this panel for one other thing, which is that you've given me an opportunity when I do address the boards of health to tell them that this is not a typical state panel that we've dealt with on so many other issues, that this is a panel that seems to be listening to every nuance and every comment. And it makes my job when I go to a board of health and say, stand down, take it easy, let's see what's happening. It put some faith in the system here, and you guys are making it a lot easier for me to say, put some faith in this system because of the incredible open ears, and in fact, open hearts that you seem to have for this issue. And I just want to thank you for that.
Well, thank you so much. It's so nice to hear at 4:30 in the afternoon when we're all tired. So thank you. Really appreciate you staying on the line and talking to us. And I do think that part of the reason for this legislation was to ensure that there could be a very careful review that had a balance of making sure that local input was included in all decision making from the beginning of a process to the end, and at the same time also having a board like ours who could step back and take a look and really review all the details of a project to help towns make sure that what they have in their towns is healthy and safe. All right, do we have anyone else? Okay, can we have a motion to adjourn?
So moved.
We're supposed to discuss something else?
Sorry, I just want to make sure. I know Commissioner Mahoney maybe was working on something. I just want to make sure we
Okay, you're right.
got back to that.
Sorry.
Sorry.
Thank you. Well, you're the only one holding us between leaving the commissioner, so you better get to hop.
Noted, and thanks for the backup, Commissioner Rubin. I did share some language with Director Green and Ms. Evans. Going back to the discussion I brought up earlier about the language around DOER opinion in 14.043. I think what we would suggest is actually striking the definition in 1401 for DOER opinion. It's only used, that term is only used once in 1404, so I don't think we need the definition. And then changing the sentence in 1404, now I have to go back to it, to read, instead of the DOER opinion, we would write DOER consultation, the director may consult with DOER whether the local government's review is in compliance with any element of 225 CMR 29. So instead of saying DOER opinion and the director may request an opinion, it's just going back to the discussion that we had earlier. This is about a consultation, saying DOER consultation, the director may consult with DOER, and certainly as part of that consultation, if it's necessary at the time to ask for something in writing, the director could do that under that language. We just don't want to set the expectation that DOER is some of the points that were earlier raised. We want to make sure these are processes that are being done at the local level, and that's not DOER checking every process and every
That sounds reasonable to me.
So, thank you.
I also wanted to raise one issue before we left, even though I was the one who moved to adjourn. I do think that we need to give further consideration with respect to the constructive permit. I think my understanding from the get-go is what we heard here today, which was if you don't do the permit in time, it issues, and it issues with common conditions. And that's what I have always thought it was. I think it's worth looking at, hearing more about why this change, and I'm more than happy to hear about that right now. But it does seem a little cumbersome, and I am concerned about the issues that Ms. Matthews raises about us even able to deal with some kind of procedure afterwards.
Do you want me to respond now?
Yeah, you can. Yeah. We're all here.
Thank you. Yes. Thank you. I would like to just address the procedure piece first, if I could. The way we drafted this was that the recommended permit conditions would come at the end of the adjudication. So there would be an adjudication, there would be the conditions conference, folks get to comment on the recommended conditions, and then folks get to brief it afterwards. So but
I guess what I'm not getting about that, Joan, is that this is a constructive permit that, like, you haven't met the deadline. So how do you know that you're going to have an after adjudication?
We are thinking that it is likely to happen at the end of the adjudication, because that's when the adjudication schedule would run, and what we likely would not get to, hopefully not very likely, but likely not get to, is the tentative decision, the whole writing up and going through the board meeting type process. That's what we figured that's when this would happen. The board would run out of time at that point in the process. That is the assumption behind the way the mechanism is set up.
But now you're in a situation where you're not able to meet the deadline and with a decision. So now, while you don't have the time to do that, now you're going to have a meeting, a condition meeting. You're going to have, you're going to be working on conditions, specific to this project. I mean, it seems like a lot of extra work that would be done afterwards.
So the conditions conference and the recommended conditions, the way it's drafted right now, would happen for all projects, so that they would be going into the tentative decision, and the decision by the board, there would already be a condition conference, folks can discuss the conditions, and then there would be a recommendation would happen for all proceedings. So there's no additional work in this situation. A number of folks have raised the concern that if constructive approval issues with only very kind of base common conditions, nothing project specific, well, we understand that there's an incentive not to let that happen. I think the incentive happens anyways, that the project could be built without possibly very important protections through conditions. And that was the concern that had been raised by a number of folks. Mm-hmm. So we tried to come up with a mechanism to allow the conditions to go through the adjudication process and also apply them in a constructive approval situation, so that the project-specific protections would be in place attaching to that particular project.
So the view is that the common conditions aren't going to be adequate.
They would not be project specific.
They would not be project specific. That's right.
Yeah. Which I think, as one of the entities that gave you some of that feedback, so thank you for trying to reconcile all of the interests in this. I think all of the process that's built in means that by this point in time, like we're not going to get caught by surprise on day 364 of 365 that, oh my gosh, the clock ran out, right? There's all of this process built in that will have brought us to that point, including backtiming notices of likely constructive approval and all of that. Because all of that process will already have transpired, we'll have, 10 to probably 13 months of work on conditions, depending on the type of pathway, that will already have taken place by this point. So I think the goal is to salvage some of that good work, right? You've already heard about the potential conditions. The applicant has had the ability to respond to them. There's been lots of live conversation and written feedback from interested parties on them by that point. How can we salvage some of that good work, which doesn't necessarily automatically mean conditions are more onerous. It's just that they're more tailored to that specific site. So it's not like this gives us the ability to be increasingly more stringent about what we're requiring from that project. It's just clarity for everyone about how, in this case, these requirements will apply. So enemy is perfect to the good. I know you're trying to again, find a good balance here. And I think building in things like the conditions conference and all of these opportunities to have discussion, feedback, and really development of thoughtful site-specific conditions is really valuable.
So how would you propose that we deal with the siting board piece of that, the board voting piece of it?
I think some of the discussion on the record prompted by Commissioner Rubin's and Chair McDermott's comments earlier would be helpful. We recognize, that language in, 17.05 is new and could just use some of that fleshing out that was discussed earlier, including for the board's own clarity on, the upvote. You have to adopt all of the conditions or none of them. I think that was a really helpful colloquy that occurred before, and just finding a way to reflect some of that in the regs so that everyone has that memorialized for going forward purposes would be helpful.
Commissioner Mahoney, do you have a view? No.
No.
Anybody, any other board members want to talk on this issue? Okay, well, you will review and we will deliberate at the next meeting after we have people's comments and think about it further.
Thank you.
Okay, anything else? Am I missing anything, Commissioner?
I'll just add, before I make a motion to adjourn, I just want to, again, there's been a lot of things, but it's been incredible to work so closely with the staff team, with the board, and not our staffs that are not present with us today have all weighed in, and it's been incredible. I can't believe we're in early January and are as far along as we are. So I just want to acknowledge that from myself and thank everybody who's been instrumental. And I'm looking at a lot of people, and there's more in the room who are not here that should be thanked. And with that, motion to adjourn.
Well, I will add one more thing, which is, we've had over 90 people on this call all day today, all afternoon today, and really want to thank you all for coming, and also for the amount of work that everybody, in addition to the staff, but many stakeholders, many local municipalities have spent looking at these regs and commenting on them. It's been a very much a team effort. And we know that it has been a very quick process and that people have had to spend a significant amount of time on this. I'm hoping that at the end, we're all going to be proud of the work that we've done, but want to thank everyone for taking this so seriously and spending your valuable time on it. So motion to adjourn.
I will second that motion and the thanks as well.
Can we have a roll call vote, please?
Chair McDermott.
Yes.
Commissioner Rubin.
Yes.
Commissioner Mahoney.
Yes.
Commissioner Heipel. Mr. Gutro.
Yes.
Mr. Bonfilio.
Yes.
And Chair Tupper.
Yes.
Motion carries.
Thank you. All right. Well, we will see you all in February.
Good night. Thank you.
Thank you.